All right, good morning, John. I have 10 a.m. Are you and your team ready?
We're ready, Chief.
IT is ready?
We're ready.
All right, well, good morning and welcome, everybody. I would call this meeting to order. Iris, if you could do the roll call, please.
Chief Stan Stanridge.
Here.
Assistant Chief Jessica Anderson.
Here.
City Manager James Devlin.
Here.
Lieutenant Clifford Drake.
Here.
District Attorney Carlos Garcia.
Here.
HR Director Christy Lewis.
Here.
Mr. Robert McCabe.
Here.
Mr. James Parnell.
Here.
Captain Dennis Rice.
Here.
Chief Victor Rodriguez.
Present.
Mr. TJ Spetzer.
Here.
Ms. Jennifer Szymanski. Here. And Chief Deputy Jason Warren.
Here.
Yeah.
Thank you, ma'am. Robert, you weren't at the first meeting, so would you like to tell us who you are?
Sure. My name is Robert McCabe. I live in Georgetown with my wife and our daughter. I'm an attorney. I've been an attorney for 23 years. Spent about half that time as a prosecutor in both Bexar County and Williamson County. And I currently practice majority criminal defense work, and I also do labor and employment work on behalf of the Texas Municipal Police Association as regional attorney. So I'm happy to be here, and thank you.
All right, welcome. I think welcoming remarks. I'm just going to say this for the benefit of the persons who may be viewing online, the virtual audience, that the Misconduct Investigation and Hiring Procedures Advisory Committee, which is us, is charged under Texas Occupations Code Section 1701.4522 and .4535 with developing model policies, quote, establishing procedures applicable to a law enforcement agency investigating alleged misconduct by a license holder employed by the agency and hiring a license holder and regarding personnel files maintained with respect to a license holder, end quote. So that is why we are here. So with that said, did everybody have a chance to review the minutes from October 10th of 2023? Any needed corrections? Hearing none, I'll entertain a motion to approve the minutes from October 10th, 2023. So moved. Second? Second. Okay, all in favor say aye.
Aye.
Any dissent? All right, minutes were approved. What says our co-chair?
About what?
Anything. Welcome, Jessica. Do you want to say anything to the group?
No, I looked at the attachments that you sent out and I'm excited to get the conversation going. I think last time it was a good starting point, kind of level set. But now I'm ready to get the work done. Excited to see what today brings.
Good, welcome. I'm going to turn it over to you for any procedural things that we need to knock out.
Thank you, Chief. The only thing that I have, good to see everybody this morning. Thank you all for being here. Appreciate everybody being here and in person. It certainly facilitates the conversations and discussions that you'll all have moving forward. Again, thank you again on behalf of Tico and the commissioners. Chief, one note that we are not live streaming. Actually, we're just recording, but everybody gets to see themselves from time to time. That's fantastic. It's in the record, but we just wanted you guys to know that this meeting will not be live streamed, but it is being recorded just like the last one.
All right, anything else?
We look forward to today's discussion.
And Iris, as we get closer to lunch, you're gonna have to help us navigate that process and what that looks like. And then don't forget if you have any other receipts, et cetera, for lodging from last night, Iris. All right, so we have quite a bit to do today. We need to review basically 4 components. Luckily, the subcommittees provided draft language. I would think it would make sense that we begin with may investigate. Would everybody agree with that? So, Mr. City Manager, you chaired that, so why don't you run with that?
Well, it was a great process to work through, and give Chief Rodriguez credit because he came up with a pretty solid working definition to start with. It originally started as a policy that listed out types of investigations and morphed into the attachment you see here today. We believe that the language that we came up with does what we're required to do by the Senate bill. So if you look at the bolded area, for purpose of misconduct, violation means a finally sustained allegation of violation of law, an agency policy, or a finally sustained allegation of untruthfulness that results in suspension, demotion, or termination. Finally sustained shall mean that the alleged misconduct is final and not on appeal. Because we all know how that process goes, either through collective bargaining or civil service agency, that final disposition can be changed. And so we want to ensure that the due process takes place before it is ever sent down, if there is a suspension, a demotion, or a termination as a result of that investigation. And you can see down, it's comprehensive, it addresses what needs to be done in Senate Bill 1445. Administrative, these are the actions that are most likely to be appealed. One caveat that I did have that we discussed, and Chief Standridge and I, for new chiefs that may come in, there was a working list, kind of officer-involved shootings, untruthfulness, sexual harassment, those type of things. We were just somewhat concerned, or had a little bit of concern that new chief may not know, right? I'm not bent on having the list. I think what we have been provided covers what we were charged to do. And so with that, I'll open up to any questions that anybody may have as a result of that. But I think it's a very good starting point for us, and I think it fits exactly what we need to do.
I would ask from staff, what your reflection on this might be.
Sure, Chief, to get everybody started. I think we go back to kind of the main flow chart that we were discussing, and I think it's fantastic what you guys have put out. So it's certainly I think it initiates and invites a lot of conversation. I know we had a lot of discussion, and there is one distinction that I want to make, though. When we talk about, it's not necessarily may investigate, having the discretion to investigate, but I think when we talk about may suspend, demote, or terminate, part of that, that's where that discretion was. But I still think the principle that you laid out applies. I know there was some discussion last time, and I think I'm reading a little bit of that in this about what misconduct means. And John, if we could go back to the flow chart, please. And I do this for the purpose of just we're all kind of looking at the same thing here. Misconduct means a violation of the law, violation of law enforcement agency policy for which the agency may suspend, demote, or terminate, and the allegation of untruthfulness against the license holder. And if I'm understanding this correctly, this is an attempt to start scoping that down a little bit. Would that be correct, what I'm reading here?
Yes.
Yeah.
I would agree with that.
Okay.
Yeah, I mean, the way that this whole conversation started was basically I just sent a policy that's a TPCA accredited policy.
Sure.
So we gotta start a conversation somewhere. So basically
Absolutely.
it's what has to be investigated by my agency. And I said, well, what are thoughts?
Yeah.
So it seemed pretty basic to start. And then we got to this point here where we came up with this working language. I believe it fits. I think the subcommittee believed that it fit what we were trying to get done. I think we're, also as administrators, chief administrators for agencies, I think and I don't know how it would come back, but what if we send one down and it's overturned? So what is the process of pulling that out after an arbitrator or an appellate court says, no, they can't be suspended or terminated or demoted. So I don't know that part of the process, but I think we're charged with ensuring that whatever gets sent down is true and correct and factual and is not going to change. So, that's my 2 cents. I just don't know how you recall it, because we know it's going to happen. I know it's going to happen. We're going to get one that gets sent down. It's going to get overturned, and then it's going to be sitting there, and it may not be true. So that's my fear from an agency standpoint. How does that reflect? How do we get that back?
John, I would add to that I think that 1445, to some extent, gave us some leeway. When it narrowed down to items that may be suspended, demoted, or termination, I think that left everything else that we do, which you know, I'm gonna throw a number out here, maybe 60% of the stuff that we do is you came in late and we're gonna reprimand you. That stuff does not fit there. So that takes all of that out of that equation.
I would agree with that, Chief, yes.
So then the next question was the may piece, and the may is just too gray. You know, maybe I want to today, maybe I don't want to next year or whatever. So rather than play with may, we just said, why don't we keep it at what is in the end finally sustained? And that results in a demotion, termination, or forget what the three terms are here. And then we drew this language around the base of 1445, which covers everything. In other words, an allegation of a violation of law, which is the requisite of 1445, or an agency policy, or a finally sustained allegation of truthfulness, or untruthfulness. So by virtue of this, we cover the depth of ground that 1445 wanted to cover
Sure.
with us as it relates to misconduct. So anyway, that's the reasoning. That also fixes some timeliness problems with the statute, because when we say finally sustained, no longer an appeal, that means that the clock's not running until that item's completely dispensed with. So I think, you know, as close as we can get to this, that was just a piece of work here, but
Sure.
that's why it's there.
I think it's definitely starting down the right track for sure. Kind of a question that comes to my mind when reading this in the bolded, for the purposes of misconduct, violation means a finally sustained allegation of a violation of law. And we're talking about, and I kind of go back to the original premise of the agencies required to initiate an investigation into alleged misconduct. My question on is something up for discussion would be, does this bolded definition as it is right now, does that leave us in a circle where what happens to the unsustained alleged misconduct, which we have the provision for, that still gets reported ultimately in the end for future employers? Does this define away any instance of that?
And again, this only covers the misconduct piece of it.
Sure.
That's gonna fall under whatever we choose to do with the file component or the file construction of that, and how we end up doing that, just like we do 143G stuff today.
Mm-hmm.
So I think that's not necessarily circular, but it's covered in the construct of the file.
Okay.
So when you ask for a file from us, we're gonna be, depending on how the file construct here ends up being, we're gonna end up having to give you whatever we've got.
Yeah.
But if somebody asks for a discipline record, independently, then that's what we're reporting. In other words, you're getting that, you're getting that whether the employee is working with us today and 20 years into the future. You know, every time he does something, we're gonna get that to you. But at some point in time, when he's gonna move on somewhere, and somebody wants to see his whole file, that's a good.
So, on the two files then, I have to think of officers that are in like narcotics and vice. They get so many complaints that are unsustained. So all of that goes in their jacket that a future employer can look at internally, right? It's not open for public. The sustained complaints are, got it. That's pretty easy. The unsustained. So a future employer can look at one of my narcotics guys in Dallas and go, he's been there 20 years and he's had 50 complaints.
We lost that with G-file requisites.
And as it exists now, those files are accessible to future employers.
Only.
Correct. In the context of just the employment and background access.
But they're
So-
not going into a T-hole, which is what this is talking about. Because we've conflated the two issues now, and I don't know if we can avoid that. But it seems like with the statute, we may not be able to avoid it, which is unfortunate. Because now we're talking about reporting all that to T-hole in this other database, not the database that other agencies look at, but another database. Is that,
It's one and the same. What the TSS system, Secure Share system right now is going to be, that's the first step into this confidential database.
it's one and the same, but there's another step that TCOL's wanting to do with the database. It wouldn't just serve as a place for prospective agencies to go look at.
That's the purpose of it, is for other agencies to access it.
Okay, but in the second portion of this, which we'll get to, but it's directly related to this, it would be a database that TCOL would be able to access and their enforcement in terms of whether or not an investigation was actually conducted or not. Is that right or no?
Well, TICO would have access to it, correct?
And they would act upon that in some way, shape, or form.
I think right now, under the Secure Shares and the background investigation, the agency can take action against a chief administrator. That was specifically put in under SB 24. That TICO can suspend a chief administrator's license for not following background procedures and everything that goes along with it, including access to the Secure Share system.
But what about for not conducting an investigation upon termination or some other point? I mean, that wouldn't be able to be done until this is hashed out, right?
That's a new rule violation, but it wouldn't require the access to that database. First, TSS is not a database, it's just a transfer portal, so those documents aren't retained. What this would do now is take everything that's being transmitted through that transfer portal and it would rest there, and then that agency would no longer have to send it. Any other agency after could take it from that database, but it would be the same information that's being transmitted through TSS. After this goes into effect, and they're required to, because one of the big problems we're dealing with now is someone gets accused of serious misconduct, they're allowed to resign, no investigation takes place. And if that occurs, then yes, data in that database could be used to establish whether or not that happened, but it could be established outside that database, right? Whether or not
Yes.
an investigation occurred. And I think that goes back to the base level question of what you were talking about. If they're required to investigate an allegation of misconduct, and we're using an allegation to say it has to be a final disposition, then you could never have a violation, right? Because only misconduct is something that has
I
gone
see,
to a final disposition.
except for they've left room for if their language talks about upon demotion, suspension, or termination. So I agree with you on the suspension and demotion, but on termination, you would be able to see it in theory because it would be accompanying their file to TCOL upon termination, which is what we're.
Because we'd send everything out.
But those agencies who chose not to investigate it would never be in violation because misconduct requires a final finding. So if they never investigated it, there's never a final finding. So it doesn't meet the definition of misconduct. I think that the definition they're using has to do with records disclosure, but it doesn't apply to the section that John was pointing out where it says you have to initiate an investigation of alleged misconduct. If you're going to say misconduct requires a final finding.
So now you have a requisite to investigate, and it's either gonna fall in the sustained file or non-sustained file, which at some point in time you get, the non-sustained piece becomes part of the file that you have access to,
On this
and you
separate.
can make on a limited basis available to whoever the future prospect boss may be for that officer, whomever, or agency, whatever. So that's what we're doing right now with G-file stuff, right? On a controlled basis, we're making that available to you, you load it up, you take it up, somebody needs to see it, they see it, and then we're done with it. Now, this changes a little bit because you're actually gonna have to get the file.
Yes.
What I hear you two saying is, we have established what we're gonna share ultimately upon termination with TCOL, with it being a final, non-appealable decision. Your concern is, at what point, where is the compulsion to even do the investigation?
That's the absolute initial threshold question that has to be asked, yes.
So to me, these are actually somewhat different issues.
They both use the word misconduct, so in
Right.
defining that word one way, you will alter the application of
Yes.
the other section.
So if anything, this is okay, but it's somewhat, doesn't have enough. There has to be a compulsion, then once you actually do the investigation, than the reporting component.
That's correct. When do you need to do the investigation and what you have to report once all of this stuff in the middle has happened? I'll put it simply, the red box is when you have to do an investigation. And everything below that, and particularly the green and the brownish box, that's the what you have to send to TCO in a timely manner after separation. Again, one of those discretion issues you were all going to discuss.
But they're intertwined, right? Because when you have to report it, misconduct is in that. So whatever we define it as up here, it's gonna impact down here,
Of course.
which is unfortunate. Because we could have a pretty good model policy on misconduct investigations if it didn't mean that whatever that was, all of that had to be reported at TCO. But
Well, I think the other way to look at it, Jennifer, and I understand it all does have to be reported to TCO. Think about it in terms of what needs to be available to the next hiring agency. That's what ultimately the goal of it is. It's not necessarily, yes, it comes to TCO, but for the purpose of the next hiring agency to have access to the entire array of records.
yeah, I don't disagree with that portion of it.
And it's, I would say that it's not necessarily true that everything has got to be, that everything fits this way. Remember, they're asking about misconduct investigations that result in demotions, terminations, or the third piece I'm moving, right?
That's right.
So if I've got, you were late at work today and I'm gonna write you up for that, that's not a report, that's not covered under this. So when we talk about everything, I just wanna make sure that we don't lose sight of the fact that they left this room. They left this room for the day-to-day stuff that we deal with on a continuous basis. So it isn't like everything's gotta be formalized and everything's gotta be reported this way. They're saying, if you've got an allegation of a violation of law, which at some point in time is covered by policy anyway.
Mhm.
You got a policy violation that results in one of those three things. You gotta do this and you gotta do this. So, I find comfort in that in the sense that the stuff that I would say, I'm throwing a number out there, I don't know what that actual number could be, but I'm gonna say 60% of what we deal with is probably in what I call the admin stuff, the you were late to work, you didn't come to this, all that kind of stuff, that doesn't fall in.
And if I may, Chief, John, can we blow this up, please? No, go up. Make this, enlarge that, please. Center for me. Thanks, sir. I think exactly what you're talking about there, Chief, is when we get down into this right here. A misconduct means a violation of law. What does all that mean? You said at some point it reverts back to policy. As a committee, y'all can consider excluding Class C violations. That's not gonna include, if you don't want it to, every speeding ticket that one of your licensees gets. Or everything, a violation of law, excluding everything other than Class C misdemeanors except family violence. There's a million ways you can do this. You have the discretion there, I think, to limit what comes in the top. This is the top of the funnel. This is the top of the funnel right here. And I think there was a great deal of discussion right here. I think the violation of law, I think you all talked a little bit about what the parameters are on that, but I think, as you've all noted, the second part is going to be the bulk of what comes in right here. How often does somebody get a felony in your department? How often does somebody get a DWI? Not as often as you're going to have conduct which may result in suspension, termination, and everything goes along with it. So what is the bar for this second bullet point? Is it every single disciplinary write-up possibly? I don't think that's the direction everyone wants to go, and I don't think that would be a wise policy. And I think it's a wise policy not to do so. So may suspend, demote, or terminate. So it comes down to, it's pretty simple. If they've violated policy which may result in termination, that's pretty egregious conduct. So where I think you have an opportunity to really scope this down is the may suspend or demote. What kind of conduct right there should be worthy to report and put into its alleged misconduct investigation that could result in disciplinary action. What level of conduct for the future hiring agency, think about this in the end, would you want to know about? What level of conduct here would you want to know about at their previous department? That's one way of thinking about it.
Shooting.
John, the only thing I will say about violation of law, if we start carving out, a Class C traffic violation may not mean a whole lot, and so therefore, Class C violation is not going to be one of those that fits the definition because it's not suspendable, demotion, or whatever.
Sure.
However, a Class C 10 times in a row, maybe, so that's why I'm saying if we leave it the way it is, that it's a violation of law that results in a suspension, demotion, I mean, I think that says, you know, you're not gonna get suspension or demotion or otherwise for committing murder, you know?
Yeah.
So, but if you get a traffic ticket, which some of us got some on the way up yesterday, no, I'm just kidding, all right. But, you know, a single one of those incidents is not gonna be something that's gonna result in
Sure.
demotion or otherwise. But someone could have 10 or
But maybe when it hits that point, that's what triggers the shall investigate, or you required to do
And so,
investigation.
John, what I think I hear you saying is that we need to drill it down a little bit more, that conceptually those, we understand what these words mean, but we have opportunity to clarify what exactly violation of law, what does law mean? And I'm going out on a limb here, but I would venture to say that we would all think that demoting and termination is something that should be reported. Maybe not Class C tickets the first time. Where I have a little bit of heartburn is what does may suspend mean? Because, for example, we are going to be putting in policy that if you go through an intersection and don't clear it, you're gonna get automatically 3 days off. That probably doesn't matter to your departments, but that's a big deal for us. That would be a suspension. Does that mean that everybody else wants to know that? Probably not. So I think we may need to narrow what we mean by may suspend, because that could be a lot of different things for a lot of different agencies.
And I think that's exactly the heart of it right there.
The problem with that is, you know, May is gonna be different to every one of us, and
That's why we're here.
we don't wanna leave this, you know, come back again 2 years later and go to sunset again and have to address this again in the legislature.
I think that was clearly their intent. If you have a policy for someone may be suspended for that, you can't ignore allegations of violation of that policy. And to address what you said about getting 10 citations, nothing in this will prevent an agency from investigating any allegation.
Right.
This is just a trigger which will require them to do that. So I think that's why John's saying you could exclude Class C traffic violations. It doesn't mean you can't. If you got a guy that gets a speeding ticket every week on his way to work, then yes, you can investigate that. It just won't be required by this policy. It's finding the point that an agency will be compelled to conduct an investigation. We have agencies.
And I'm
Did
not
custodial interview-
arguing against it, I'm just saying that if you start carving out, then we run the risk that someone on his 10th Class C violation, you wanna maybe do something that's reportable, and we may be shooting ourselves in the foot.
It will be reportable. You can investigate, you can report, you just won't be required to investigate.
So am I hearing you're kind of wanting a specific list? Is that kind of where you're going?
You could certainly try it that way. I think that would be a good start, at least it could stimulate the conversation to, and I agree, demotion or terminate, that's pretty clear. Those are pretty, according to policy, those are pretty egregious actions. May suspend though, that's where, that's why we have all the experts in the room right here from a variety of viewpoints.
Well, I mean, to me, the may suspend, I probably could suspend for almost anything. That's the problem. And I understand, I believe I understand what they're trying to do, but I don't think that it's fair that we, well, I guess if it were, let me take that back. We're gonna put ourselves into a lot of work, I think. What we originally started with, again, I said, I used the TPCA policy, best practice policy, for what is required of an investigation for an agency, right? And they're pretty standard across any of the accredited agencies. allegation of criminal misconduct, excessive use of force, untruthfulness, allegation of unlawful search or unlawful arrest, violating person's civil rights, racially motivated police actions, officer-involved shooting, sexual harassment, creating a hostile work environment, or any conduct that seriously degrades the integrity or good order of the department.
That's a good list right there.
Yeah.
So I mean, I think that listening to what you were saying, that covers some of this, right, or covers most of it. I guess the problem that, I mean, does that sound okay to everybody? I mean, I don't know.
That's a step in the direction, I think, that certainly if y'all want to scope this, I think that's a step in the direction to have a conversation to do so.
Right.
Because remember, some agencies, even in the circumstances you mentioned, they're doing nothing as far as investigations into that. So even knocking off the most egregious conduct is a step in the right direction.
I think you could take out the agency may suspend, demote, or terminate and just replace it with that list. And then we move on to when that's reported to TCOL.
Yeah, I agree. I mean, again, I thought that would be a decent place to start. You know, if that's the direction we need to go, then it's already a best practice in the state. You know, I don't know about CLIA, if CLIA has something that's similar on creating an investigation or starting an investigation. But, you know, I just don't want to get us into a position where, you know, we have somebody doesn't clear an intersection, you know, and now I don't know, how are you guys gonna even send that down? I mean, are you gonna create a whole nother division for Houston PD to do that? I mean, this is gonna take a lot of work to send this stuff over and over again. For larger agencies, for us, it's, you know, it probably won't be that much of an issue, but, you know.
I think those events that you just talked about that could result in suspension, again, it's got the added benefit of already being in an established policy. So this is not going to be something out of left field. This is going to cover at least, the very least, this most egregious conduct. Obviously, a department there's nothing that prevents the individual department from launching an investigation to anything for traffic tickets, for anything less than the conduct that you discussed.
Well,
that's
that's why I left that bottom one about any conduct seriously degrades the integrity or good order of the department. I think there needs to be something there to allow the chief some discretion on that type of investigation. I mean, and that covers the Class C, multiple citations, and anything else that may come up.
Because I don't think you want as an advisory committee to create some exhaustive list that these are the only things. Obviously, these are the guiding posts, but you do have that last category that now, so a chief administrator doesn't believe, oh, I can't do an investigation.
Because it's not listed, yeah.
That's right. You know, and similarly, when we talk about an allegation of untruthfulness against the license holder, this is just to stimulate conversation. Is that untruthfulness an illustrative list of instances which that would trigger an investigation? Could be if it was untruthfulness as part of an investigation, i.e. a warrant, a probable cause affidavit, something, again, scoping this to where there's at least some idea of the instances that would trigger when this alleged misconduct investigation takes place. Is it on a government document related to the duties and responsibilities of the licensee? Instead of just, you may or may not want to include, okay, this licensee made a untruthful, what was determined to be an untruthful entry on a timesheet. Do you want that in there? Again, that's things.
I mean, every other arrest we make, you're gonna have someone say, he's lying about my arrest. Okay, so, and again, if you don't pin this down, if we don't pin this down soundly right now, then we're not fixing anything. We're not fixing, you're gonna allow me and people like me and all over this place to say, well, you know, it's not an allegation. Or if you go the other way, everything's an allegation. Every other arrest we make, someone's coming out and saying, no, he's lying about me, I didn't do this.
That's why you have the finally sustained language, right?
So that's why I'm saying, if we, you know, what is misconduct is defining it as someone that is sustained, and only reason I put there suspend, demote, or terminate is because that's what the statute built into it. I don't think we have a way around suspend, demote, or termination.
Let me ask you this, is untruthfulness the same as false and misleading statements?
You could include that, I believe.
You have,
Is it
sorry.
the same though, in regards to false and misleading statements versus untruthfulness? Tell me, what's the difference?
That's a good question.
You could define anything you want to here. This is the trigger that requires the
Right.
investigation. One of the things we deal with are personal history statements and whether or not people made omissions and whether or not that was an untruthfulness or a lie. And part of what we look at is whether or not there was intent, whether it's possible they actually forgot something that happened 15 years ago and just failed to include it in that. And if we do, we find that they made an omission, which was relevant, but we don't accuse them of untruthfulness in most cases or lying. So I think that you could define untruthfulness to include some level of intent or some other thing attached to it to scope those allegations of untruthfulness.
And if, I'm saying this, if we try to define this further, I'm not trying to define, I'm just saying, what in the end is a violation? There are some things that are, and it's not perfect, but a sustained action that resulted in this, that's pretty solid, whatever it may be. But if we go into defining some of these other things, then we're leaving room for, well, that's not the way I read it. And we've got a US Constitution that's 200 plus years old that we're still interpreting.
It's the imperfections of the King's English. It's unfortunate, but that's it's not algebraic. I totally agree with you.
So if somebody's gonna say, well, that's not the way I read it, if we create that room now, then we're shooting ourselves in the foot. We're shooting ourselves in the foot here.
So do
So-
you have objection to the list that he read off, or is it, I guess I'm confused as to your.
I'm not gonna say objections is my word of
Okay,
defining that, I'm just saying, I wouldn't. If you start carving things out like that, I think wherever we start carving out, we're gonna start leaving room for, I read it one way, you read it another way, you read it another way, you read it another way.
But do you want to know when I suspend somebody for 3 days because they didn't clear an intersection?
I don't want to know that, but I think that we did something in Texas that resulted in scrutiny by the legislature that says, the heck with it, you're gonna investigate and you're gonna let us know this stuff.
But
That's
the
what we're dealing with here today.
legislature also gave this committee discretion to revise it and refine it to a way that works for the benefit of the department.
If you don't want to report suspensions for 3 days for having an accident or running a traffic light or whatever it may be, you wanna carve that in there, that's fine. That's pretty singular. But if you start saying 3-day suspensions for anything, well then, the guy commits murder, I'm gonna keep it on a 2 day so I don't have to report it. I don't wanna, let's not leave room for games like that.
Yeah, can you read that again?
The list.
Yes, please.
Allegations of criminal misconduct, excessive use of force, untruthfulness, allegations of unlawful search or arrest, allegations violating a person's civil rights, allegations of racially motivated police actions, officer-involved shootings, sexual harassment, creating a hostile work environment, any conduct that seriously degrades the integrity or good order of the department.
So I actually think may suspend is too broad, and I would prefer we kind of narrow that scope. I think that gives more direction to the agencies, not less or creating more confusion.
Well, I want to say that your 3-day suspension for your officer, if they're let go or I'm looking at hiring that officer, I'm going to see that anyway through TSS. So I mean, it's already sitting there. We get it. We already get it.
But let's use that example now. If someone in a sergeant's reviewing tapes and he sees someone who clearly didn't clear the intersection, they didn't get in a collision, right, but he discovers it reviewing the videotape, he sends it over to IA, and that person quits that day and applies with Harris County Sheriff's Office, will your agency finish the investigation regardless?
We will now,
Okay, but in the past you would not have?
probably not.
And that's what we're dealing with is, does Harris County get that information? If she's saying, we'll finish it now, then they have 30 days to disclose it. Harris County has a 45-day probationary period, and once they find out about that after the fact, they could terminate that person if that would have made a difference. The question is whether or not an agency is required to investigate that conduct, because a lot of agencies now, when that person leaves, they just choose not to investigate it.
I agree
Usually
with
it's a lot more serious than not clearing an intersection.
I get it. I understand it.
So that's what we're talking about is when will the agency be required to do that investigation so the next agency will get that information? I think we're getting it mixed up with what documents will be and what will they have to
Right.
disclose, but we got to get past the do they even have to investigate it part.
But that again goes to the whole point of what we were saying last meeting, which is most of the examples you're using have to do with when they separate from an agency, which we all agreed would be reported to TCOL anyway, and then we can expound upon that.
If it's
But the-
investigated, we're talking about whether or not it even gets investigated, not disclosed.
Right. But again, that one was, and I think this will be talked about in the next part of the conversation, but it's upon separation, that example that you gave. So, that's also kind of narrowing the scope here because termination, we have suspend, demote, or termination. And John, you had mentioned that you don't think we can get away from suspend, demote, or terminate. Why don't you think we can get away from that? We can't replace that with something? Or eliminate suspend?
I mean, I guess my response would be, what would you replace it with? That's what the
Well,
language of the statute is.
Either the list that's being talked about now or take out suspend.
No, I think, let me be clear. You have the discretion, I believe, and I think we've discussed, that you can articulate instances of what suspension means. Like James just gave a few minutes ago, you can give that list.
Most of the lists that he gave would definitely result in, if sustained, would definitely result in demotion or termination. Those are not just miniature,
The last one, the caveat, a lot of agencies aren't gonna terminate or demote for that. If you can demote, you can terminate. Most of us would say that. But that last caveat gives me the ability to, if I have something that's on the fringe that I hadn't contemplated through policy, I can still suspend because it gives me the discretion, but it may not lead to termination.
I think the only one in there I have a problem with is the untruthfulness, and it's for the reason that the chief said, there's way too many allegations of untruthfulness to fit in there. The rest of them, you can say them again, but sounded like, I would be surprised if sustained on any of those, that there would just be a 10-day suspension or a 15-day suspension.
But that reinforces, from TCOL's perspective, the reason to include the list.
No, I'm agreeing with the
Okay.
list.
So
I just-
let's gather consensus on the list, and then if we need to further out hammer out untruthfulness, we can. Because I agree with what James said about, is there motive? But
I have a question. So can we redefine, instead of trying to come up with a list for suspend, what I deal with on a lot of discipline is petty suspensions like a shift or a couple of days off. You're talking about, a lot of times it's less than 24 hours. So what if we changed and said he may suspend for less than 24 hours? So if someone gets 3 days off and that's a 24-hour suspension, that's not mandatory reportable because it's kind of petty. But if you define suspension as something greater than 24 hours, that to me will automatically trigger, well, it's serious enough that someone got 2 or 3 shifts off, so it needs to be reported. So instead of having to come up with a list of violations, maybe just come up with an hourly amount of time off as a qualifying suspension.
John, the only thing I'll say with that, you're giving us room to play, man. If you say 24 hours, you know what, okay, you know what, this is really bad, and another day I would have suspended it for 10 days, but now under this, I'm gonna do it for only 16 hours so I don't have to report it. Let's not create this mess again.
Colin, you were going to say something a minute ago.
Well, kind of conversation lost me or left me. I think what the city manager's talking about, that behavior-based, all of those things are things that's what, when you're walking the halls at the Capitol, that's the behaviors that they're trying to regulate. That's the behaviors they want investigated, excessive force, racial profiling, all of those things are the words they use. So I think that narrowing it that way, where there are certain things, I don't think they want in as much involvement in a guy's late. You can get terminated for being late to work. It just takes a long time. I don't think that's what they're trying to regulate, but that excessive force, lying on affidavits, those are the types of behaviors that they're expecting to see investigations on. And so I think you're on the right track with trying to narrow in those fields. And so that's what I was going to say.
And going back to that, Colin, going back there, in some places, there's none of this being investigated into nothing. There's nothing in the file. Simply nothing occurs. So as a prospective hiring agency has nothing to base that on. It's not necessarily the 3-day suspension or 24-hour suspension or whatever the case is. Those are going to be in the file if a department's conscientious and has the policies, DPCA policies, whatever the case is. They're covering these scenarios right now. Again, what we're trying to create is this minimum standard policy to at least create for agencies that don't have this information right now, are not creating these investigations in order to what events trigger what they have to do. Agencies may be doing this and then some right now, and most probably are. But this is for the agencies are doing next to nothing, or when do I need to put something? This is compelling those agencies to put something in the personnel file for later review by a prospective hiring agency.
Going back to legislative intent, the reason we know that and what the legislative intent was is if you look at previous versions of this bill, it originally said egregious misconduct. And that was, later removed because this committee was kind of the bargaining chip for that. But that was the legislative intent, was that there was some minimum standard for egregious misconduct, which I think your list is exactly that. And so, while we could put a lot more in there and open this way up, like Jessica said, that would be very cumbersome for large departments. This gives, I think, the legislature what they were looking for.
But I would say large departments are already doing investigations, and that
I couldn't, exactly.
that's already being
Completely agree.
done. What this is really doing, and I know during the course, and thank you for bringing up that point, because that certainly was in a previous version of the legislation as it went through the process. I know some of the questions that we discussed during the hearings, and specifically was, and it was a very interesting point that we talked about. Okay, we have the secure share system. This is better than it's ever been. Prospective hiring agencies have more information than they've ever had, no matter where you are in the state, no matter what size department you are. And the question came from one of the senators was, okay, well, what about an agency that doesn't have anything in that personnel file? What requires them to put something in the personnel file? Because if they don't have anything in the personnel file, how can you really determine whether or not they're fit? Can you determine fitness to work at your department? And the answer was there's nothing that really requires them unless they're not required under civil service or whatever the case is. What about everybody else? That's what this is an attempt to do, is at least create to put a what needs to be in a file for departments that otherwise don't have anything in that file to determine fitness down the road.
So could we, I'm just gonna throw this out there and let's see if we can build consensus around this. This agency shall investigate allegations of serious misconduct, it's not egregious, but we'll get serious, that may result in suspension, demotion, or termination for behaviors such as allegations of criminal misconduct, excessive use of force, untruthfulness, allegations of unlawful search or unlawful arrest, allegations of violating a person's civil rights, allegations of racially motivated police actions, officer-involved shootings, sexual harassment, or any conduct that seriously degrades the integrity or good order of the organization. For purposes of this policy, sustained allegations of untruthfulness shall contemplate false statements or misleading statements, either by overt means or by omission.
So it's giving them examples of,
Yes.
is that, and does it say shall investigate?
Well, yeah, because you have to, because the legislature said you had to. No, we're not getting to the reporting part. We're gonna.
Right,
Yeah,
We're-
right, this is just the trigger, threshold,
Yes.
the threshold right
We
now.
want to get the investigation done, then we'll figure out how we're gonna do the reporting.
Do we want to put something in there about the handling of evidence?
Handle of evidence?
Handling of evidence.
Oh, handling of evidence.
Is that something that would need to be a bullet point, or would that fall under any conduct that seriously disgrades? Because that to me would be something that would be, somebody planted evidence, something like that's not addressed anywhere else.
Chief, could you read that list one more time, please?
Or is it possible to get it up on the screen?
That's also a criminal violation in those
right.
cases, yeah.
Yeah, so just
It
address
would go into the criminal.
We get what he just read off, I think it's on his computer, if we could give a minute to work
And then
out how he
would we
wants to
need
do
to take
this.
off the suspend, see, do we need to keep suspend, demote?
In my world, when you say that I may suspend, I know exactly what you're talking about, because I live that world. I can't say that's for everybody's culture, but when you say you may suspend, demote, or terminate, that's basic 143. Everybody knows 143 law. So to me, it's a natural
This is saying you shall investigate. And so if we leave in, when you may suspend someone, that's going to trigger an investigation.
But remember, I qualified it as a serious misconduct. I wouldn't consider running a red light or not yielding in an intersection serious misconduct. It's misconduct, but I'm not gonna
It's
find
misconduct that you may suspend on.
That's directly from 1701-001, that's in the statute. The part that's up there, that misconduct means, that is directly from the statute that may suspend.
Right, but do we have leeway on that portion?
That's what he's trying to
That's
do,
what he's
is
doing.
define it and narrow the scope.
Because if you just
can't
read
get
this-
rid of it.
Face value, may suspend, that includes everything. Everything.
I can say serious or egregious misconduct. Just to get away from your concern that, hey, I may suspend for an 8-hour violation for you being repeatedly tardy. Does that now trigger this? No, it's not serious, it's not
Okay,
egregious.
can you read it again? Cause I think I'm,
Think
Yeah,
we're gonna
she's
get,
actually gonna put it up on the screen.
give us a minute, we'll get it up.
I think it makes total sense because of Senate Bill 23, because now you're dealing with best practices, which legislature's pushing the accreditation for all agencies,
That's right.
and they're gonna be parallel then with each other. So you're making agencies be accredited, and this, to me, it just makes perfect sense that you're putting them together. I think that's a good.
Did you all address Jason's concern? Did you feel like that was resolved or
Yeah,
not?
she said if it got to that level, you could just, that'd be a criminal.
Okay.
It would just tamper with evidence or something.
Jason, yours was handling of evidence, right?
Yeah.
Okay. You wanna take a quick break while the staff gets that up on screen? Time for a quick break? Push to about 11:45 minute break.
Yeah,
All right, so actually, just look at the bottom paragraph. And we'll unpack it after you read. Ooh.
Yeah.
And John, for the purpose of the recording, do I need to ultimately read what's on the screen or not? All right, so there's no meeting after the meeting. What says you?
On the last sentence, so this is when we need to do an investigation, right?
Yes.
So on the last sentence, should it say sustained allegation or should it just be an allegation of untruthfulness that would require the investigation?
Yes.
Yes, you're right. Yes.
So this will require that we investigate, and upon requiring that we investigate, report every one of these instances.
that's the second conversation.
That's-
Yeah. I think that's important though, before we agree to this.
Well, I think Chief's language and what we first brought up is what needs to be the catalyst that sends it. So the first thing that I read was that it's final, there are no more appeals, et cetera, whatever I can't find.
And it resulted in.
And it resulted in suspension, demotion, or termination.
I think we narrowed it a little more because of the volume of suspensions. Like we said, I mean, that's a tremendous amount of information coming in because it's gonna be there anyway for the prospective agencies, which is the purpose.
But even if we say that we have consensus today, we don't have to have commitment. We can say that this is the direction we're gonna go for, we're gonna knock out the other modules, and then we could come back and clean up this language ultimately if we find something else in the other modules. So is there anything else? We've got that change. I've already changed it to alleged allegations of untruthfulness versus sustained. Anything else?
Is it even necessary to have that last sentence?
Well, I'm trying to be sensitive to what James had said earlier. There's a difference between,
That's already addressed, that's the third.
well, TJ also mentioned this, 13 years ago, did you leave something out of a governmental document because you just completely forgot? Whereas this requires some level of motive, right? James, is that what
Yeah.
you were kind of getting at?
Exactly, and which is, sometimes it's difficult to prove or, I forgot. You can't tell me that I didn't forget. Prove that. That's kind of, so if you can prove it, but I mean, I'm at what level of, we're not talking like a criminal case here, so,
Let me take it a step further, is that's obviously going to be run aground during the investigation for the alleged untruthfulness. What instances of untruthfulness would you want to see investigated? I guess going back to the original question, would it be strictly on documentary, meaning it has to be on this is just to stimulate conversation, documents related, i.e. arrest reports, talking material, or do we want to start defining out, so you're not, again, I think the scope was the concern of, was it just simply someone in custody saying, he said X, I'm saying Y, is that an allegation of untruthfulness, or are we scoping it all the way down to, we believe there is a material omission or untruthful statement in a probable cause affidavit? Meaning that's that kind of the spectrum of what you can scope of the untruthful acts to which should be investigated. An allegation of untruthful acts which should be investigated.
I personally like the definition the way that it is, because it covers probable cause affidavits, arrest reports, it covers that. If we start drilling down and be specific, and maybe I look at this a little bit differently, but even if it's an allegation of untruthfulness, an investigation is going to be conducted, and if it turns out to not be true, then it's not coming down here until separation from my agency.
That's the thing.
So I'm not just, hell bent on that, but I think that definition right there covers what we're talking about as far as being specific, because if we want to say it's just an arrest report, well, then someone will find a way around that.
Sure.
So I think if you leave it broad, and there is an allegation, whether it's on paperwork or whether it's timesheets or whether it's whatever it may be, that's covered under that.
So what do you do with significant others?
Yeah, I mean.
This is just saying you have to
That's the
Yeah.
whole point.
I mean, and I get it, because it's going to create that work.
And we shouldn't be, I mean, I'm just saying, if it's work related, performance related, or otherwise somewhat related to a job function, either on duty or off duty, then I think this is what it's about. But I mean, I think some of us will know that every now and then you'll have a familial thing happen, and here comes one, then comes the other, and, boom, 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 boom. And is it untruthfulness? Well, it's untruthfulness.
But right now, it's just saying you have to investigate it.
Yeah, and
That's what we're
that's-
talking about right now.
So, and I've had that where somebody significant other has come in and basically lied about it, and we did an investigation. I mean, there was no way around for me to not do the investigation. I had to do it. It turned out to be absolutely false.
Which helps the officer in most cases. That's the due process.
Right.
And that's what,
Right.
that's what we were trying to get to with this
Yeah, and I mean,
legislation.
I'd hate to have something, as they're saying about an agency, not even writing anything down on one of these. And I get it, because I would be pretty upset if I was trying to hire somebody and we have nothing in a personnel file. I've never personally experienced that, but, I'd hate to have something omitted. Then I make a decision to hire this individual and find out that there's something in the background. I get it, I understand.
So this is only just clarifying and making sure I'm reading it right. It says serious misconduct that may result in. And then we're kind of giving examples of serious with what's in bold.
Right.
Okay.
Versus what Jessica cited. And to Victor's point, I have this lived experience on untruthfulness. Officers work in secondary employment at a college campus. College campus calls the coordinator and says, hey, we think the officer left campus. So the AC calls him and says, hey, did you leave campus? No, sir, I didn't leave campus. I'm still here. Calls the AC back in 30 minutes and says, well, technically, I mean, I went across the street. I literally bought a soda and a bag of chips. I can show you my receipt. It was literally across the street. Was he untruthful? Is it serious misconduct? No.
Right.
So that's what I'm trying, I agree with Jim. I think this covers it. I'm fine with this proposed language.
And so now you're looking for a what from the group?
An affirmative that we would move forward with this, recognizing that this is consensus, not commitment. We'll get to commitment later.
And that we can still wordsmith as needed
Right,
and.
right.
But conceptually, are we good with this?
I am. Everybody else? Any dissent?
I do.
Okay. Go ahead. I'll listen to it.
I don't, I mean, when allegations of serious misconduct, what is serious misconduct? And again, I'm just trying to say to you, if you come to me as a regulatory agency, as a chief, you didn't do this, and says, well, it says serious misconduct, I don't think it's serious. So I didn't do it, and I'm not gonna, and therefore, so who's gonna be right?
I'll go back to one of the opening statements that John made. Any movement of the needle is an improvement. So we're probably, Victor, to your point, I don't think we're going to catch all of them, but this is a remarkable improvement from what we're doing now.
Is that your concern, Chief, or is it, you're thinking of, is it a situation where a chief administrator should have done something or did not do something, and this is going to put them on the hook for should doing something? Is that what your concern is?
I think we should have a standard by which they are required to do something. When you put serious in here, that's subject to what I think serious may be today.
And that's
So
kind
you
of
want
why
a more
I,
tight definition of what, a more tight definition.
Okay.
So recraft this, it says that agency shall investigate these
Yeah.
allegations and take
And then
out.
A
the
strong language starting with shall, and then boom, you kill it with serious.
and that's why I asked if there's still room to wordsmith, because I do think that we can work with the language to tighten that up. But for purposes of this conversation, I get where you're going, I get where the group I think is going, but yeah, I think there's room to make it clearer with the way that it's worded.
I think if we understood the enforcement piece as well, that might help
Yeah.
some of our administrators. What's that going to look like? There was a comment made about going back and looking at like personal history statements. How is that currently done? Maybe is that going to be the same process by which, you look at these types of things in the future? What does the enforcement side look like with this?
I think first of all, when we're talking about untruthfulness or omissions of a material nature where there's intent to do so in relation to personal history statements, I think that's separate and apart from this.
How does that occur right now?
And I think, if I understand your question correctly, usually we get complaints, and usually those are based off somebody getting hired and they failed to disclose something that is later discovered that would have been very material to whether or not they were hired. And so I would anticipate this is the same thing. Someone gets hired, and then they find out that at their last agency, the example I keep going back to is they were interviewed by a federal agency in relation to a child porn investigation. And they allowed them to resign, they didn't document it, they didn't investigate, they didn't do anything, they got hired by the next agency. And so then our complaint usually comes from the other agency is, how was this not investigated, how is it not documented, how is it not disclosed to us? And then we have
And
to
so
go back.
that's what you're doing currently in enforcement.
That is one of the key things that we're doing right now.
And what does that look like? So what's the next step? What ends up happening in a sustained case like that where you determine, yes, there was information in this agency that was not disclosed, and then do you go back to that?
Right now, there's not a requirement. That's what I'm telling you, is they're not required to have investigated or documented
Well,
that.
what do you do currently to remedy that? Do you go back to the agency where they were hired and say, hey, we have evidence that they were, what's the final piece of that enforcement currently today?
They're the ones making the complaint right now. We hired somebody, how come the last agency didn't investigate or document this? And in most cases, I don't have a mechanism to address that, right?
Because there's no standard requiring them to investigate it in the first place.
But now there will, so you can go back to that agency and
Correct.
say, you should have done this. Maybe it's an education component or
Right.
maybe it's.
Whatever.
It could be.
It's absolutely.
And I would hope it would happen less since they will have a policy of
Yes.
their own that requires them to do that, right? Right now, that the argument is, well, we don't have to investigate that. I just let him resign. That was embarrassing enough that
Right.
we hope that would be enough.
And you hold the department head responsible, the chief or the chief administrator, correct?
Right now, we don't because there is not a rule
But
that.
going in the future, you're not gonna hold like one of my majors or someone else that's responsible. You're gonna just hold the chief or the department administrator for this, correct? Is that the goal?
Well, it's not necessarily the
I
goal.
can't have, you can't have lesser troops getting in trouble for this when ultimately the chief is responsible for this.
And I think that's part of what this committee will decide, because ultimately, it's their own policy that was violated. So I would hope that they could investigate and resolve it first, right? Again, what we're talking about is a very small group of agencies, and usually they're very small agencies, right? So the question is whether or not they can resolve it. We're not talking about Houston Police Department, right? That's not, most of the agencies that are represented here are not the ones that are the problem. If her agency fails to investigate something that they're required to, and it's in their own policy, they will investigate that and remedy that themselves. It won't come to me. It won't come to TCO in most situations.
And that's obviously, it's like anything we do, is that's the first step, is to try to educate and get the department. A lot of times it's simply, as TJ mentioned, it's sometimes a smaller department, maybe one or two persons in that department. I didn't realize I had to do that. Well, you have to, and you educate them through the process, and they have a better understanding of it, where you've created a better process for that department and the people they serve in the area.
But to Jennifer's question, I'm just curious, did Senate Bill 1445 contemplate any type of penalty provision?
No, it doesn't specifically have an explicit penalty provisions or sanctions. I think it would follow just like any of the other licensee requirements. Violations of TCO statute or rules are subject to some sanction anyway, from all the way from education all the way up to potentially revocation, which is obviously a rare and unfortunate event.
And the other thing that's important is we don't just address the chief administrator. Sometimes we address the agency itself, right? So that there are mechanisms that allow us to either send a warning letter, reprimand to an agency, or even to use monetary fines. It doesn't have to go to an individual person if it was a systemic failure by an agency.
Correct.
I'll make one more observation as it relates to this right here. This tends to expand 1445 as opposed to staying within or narrowing it even further. If I go back to the opening discussion we had, 1445 asks us to conduct investigations and report certain things, which I thought, I used the number here, left about 60% of the stuff, off the table, so to speak. This recaptures that. Just to kind of be clear.
But it narrows it, I think, because, it narrows it because the subsection I says a violation of law enforcement agency policy for which the agency may suspend, demote, terminate, and we've changed that to serious misconduct, which is a pretty significant, now we're really narrowing it down.
Well, again, it depends what serious means. And
Well, I think that's what the
and this list is not exclusive. It's not over, it's open. And what 1445 is left for us is conduct for which you demoted, suspended, or terminated. I just see that as we want to know the big stuff, kind of stuff. And here we're kind of walking backwards as far as that is concerned.
But I think
I understand what we're doing, whether you have this or not. The construct of the file later, you're going to get anyway, whether this happens pursuant to 1445 or not. I understand there's some agencies that aren't doing it. I understand that. And I unless you want to put some language in here, if you are Chief X and Chief Y, you better do this. It's fine with me, but let's do it right.
I don't think this list will ever be comprehensive as long as we hire humans.
Yeah, and one of the big reasons why, like John pointed out last meeting, I think, is because it's relying on and I think you did too, is it's relying on an agency's policy. So there's no consistency there. We could pass this, or we could put this into rule and then agencies can change their policies. I mean, there's no way to make it comprehensive in this. I mean, legislation in the future possibly, but I think this is this narrows it down to me to, it's pretty clear what is required.
So this second foot, so to speak, is now, we're not gonna talk about personnel folders yet. We're not gonna talk about hiring procedures yet. I think we now need to delve into reporting to TCOL, specifically timelines for reporting to TCOL, because to me, that's the second leg of this pair of jeans. Does everybody, go ahead.
Can I add one important thing to what Jennifer just said is that it is true that policies vary distinctly from agency to agency, but they have given us a list of policies that every agency has to adopt and send to TCOL. And I think that, again, helps give you the direction of what they thought egregious misconduct was or where those are. Use of force, vehicle pursuits, professional conduct of officers, domestic abuse protocols, that list that's in statute there could help show where they intended for that narrowness to be, right? And not to be the other things being late, tardy, other things like that he was talking about. So those policies have to reside with TCOL at some point. There does have to be some consistency in a lot of those, and so that would help.
But there's not even any consistency within those policies. In Dallas, we don't chase. We don't foot chase, we don't car chase. Troopers, they chase till the end of the world. That's their policy. So, well, you got a whole gamut there. When you talk about policies,
But there aren't agencies that don't have those policies. I think that's what the key is, because there are
Correct.
agencies that have no policies if we didn't require them to have them, right? Again, we're talking the outliers. This is a minimum standard. We're not trying to define the agencies that are already doing those things and doing them well. We're trying to get the people who don't do them at all.
What you have here, and I'll leave this, I guess, I know Chief wants to move on to what goes to TCO, but I think overall the thing to remember about this, the important thing is this respects what you all have done so far, keeps intact agencies' policies that go beyond this. There is still nothing that prevents an agency from doing an investigation into each separate, no matter what the suspension term, no matter what the case is, a reprimand, whatever the case is, this still, what you all have done so far, this is respectful of existing agency policies. But what this does is essentially creates policies for where there are no policies, so.
Okay. James, you good?
no, I'm good.
Okay. So the 3J subcommittee, y'all can figure out who that was, Jennifer, Jessica, James. They were tasked with discussing how to interpret 1701.4522, specifically Section BF, regarding submission of a completed investigation. It is the subcommittee's interpretation that submission of completed investigations is upon the employee's separation. So let's start there. This was a huge point of conversation in our first meeting. So Jessica, you were part of the 3Js. What said you all?
Based on our experience at the Capitol, when contemplating this section of the legislation, we thought that it was upon employee separation. We talked a little bit about whether we could change that up depending on agency size or application of 143, but ultimately determined that we needed to know what misconduct meant to have a more robust conversation. So I think now we're closer to that point, and I would like to hear arguments about why it should not be on separation.
So I think last meeting, I said I was good with it submitting within 30 days, but after rereading Sunset, talking to some people at my agency, I think upon termination is my vote. I think that just makes sense. Now, I think there'd be nothing wrong with an agency submitting it earlier if that is their workflow. If they say, hey, we're done with the investigation, we want to go ahead and send it to TCOL, I assume TCOL would accept that if we leave that open as an option, but the requirement, I think, is upon termination.
No later than 30 days after,
I'm
and
comfortable with
to
that.
allow for
Appeals.
Correct.
earlier if you want to.
Right.
And appeals.
Because you have 10 days statutorily in civil service to file an appeal.
This,
And also, if I leave in lieu of, if I resign in lieu of termination, or I decide I wanna go work for San Marcos, all of the information would still be available through Secure Share, right? So this is not,
We are hiring and yes, we'll hire you.
So you're saying this applies only to the investigation?
yes.
So we do all the stuff that we're supposed to do, we just went through all that stuff, and then we define what might be sustainable stuff, we talked about that. At the end of all that, I don't worry about it until the guy leaves my department.
Yeah, you don't worry about submitting it to T-Cole, so, I mean, you're still doing all your stuff.
Right.
But it's a submission to T-Cole, that's what we're talking about.
So, we're trying to merge TSS in this, right? Is that what I'm understanding? So in the future, so how does that, so we still go back to old school, go and show up at the agency and look at the file? Because it's not necessarily, if you send it, and I somewhat agree on the termination part of it, is if we're sending it piecemeal, it's an incomplete file. But we want to have the information so people can see it. So,
No doubt there's a bit of a workflow gap
Right.
with all of this because most people don't wait, 60 days and then apply for another agency. So you still have to get the file, I think, directly from that agency if they are still currently employed.
and the window increased as far as after we hire them, right? We have, how many days now? Did that increase if we discover information? 45.
Jessica's not here, she's over IT, so I don't want to speak for her, but I know she would tell you that both systems will continue to exist in some form because there is tons of records that preceded this that will still have to be accessed through TSS, right? And so that is the primary tool. They can go do in-person visits if both agencies agree. I'm not sure where that wording came from, but that's the way it is in statute. But TSS is the primary sharing tool. Going forward, agencies will send everything on separation. Once it's there, it would be easier to obtain it there. You could obtain several agencies' information at once rather than through TSS. But it's not meant to replace it. That will take a generation.
It's just basically merging the two, but those still exist somewhat separately from each other.
What is this second system? Have y'all even got that? Are you going out to RFP or what?
We're still working on it internally. It'll be up March 1st next year as well.
Would you consider some language that said the submission of the complete investigation upon the employee's separation? I would suggest maybe something like not later than 30, 60 days from whatever date, whatever time period you want. And what I'm saying to you is if I finish my stuff and I'm done with it, let me turn it in now. Why wait till the employee's separated? I don't want to work that stack up for 20, 30 employees that I may have all of a sudden, leave. So I could turn it in anytime except.
Yeah, just.
But not later than.
Right.
Something like that. That'll save the stacking up of work, so to speak.
Sure.
And thereby the risk of failure.
Sure. And I think what you guys are, if not later than 30 days after separation, if I heard that correctly. So I think, that would cover, if you're going to do it sooner, as discussed earlier, entirely up to the agency, whatever their workflow is.
And this is just a synopsis, right? I'm not submitting the
It says a
entire.
summary, it
Yeah,
says a
okay.
summary
It's a
of
whole
the.
thing, it's a whole investigation.
I think, no, it says a summary report.
I think it's a summary, correct?
Correct.
You want an investigation that's,
Correct. Yeah, it's like happens with TSS right now.
Okay.
Okay. Let's say, I know HPD, we've done this before, worked through where they give a condensed report, same they would give if they go to the courthouse, the federal courthouse, they're gonna give that to the judge, an IA report synopsis, instead of, stack this high, that's the IA report from 24 different witnesses, all the body cam footage, everything else that goes along with it. The general principle is, if the hiring agency wants to see that, get into the weeds with it, then that's right. Yeah, that's right. And I mean, the statute requires, let's not forget, we've got two different kinds of reports here. You've got the report that's related to the criminal charges when those are filed, and that's a little bit different than all the other administrative investigations, which I think we we're talking about here. The criminal charges don't have that after separation qualification like all the administrative reports do. And it's, again, to the point, it's a summary report to TCO for administrative investigations, including a disposition of the investigation and informational findings in a timely manner or no later than 30 days. So I think you could have a summary report, maybe that's something, a form that gets discussed here along with a unified report that gets submitted to TCO. I know we discussed that a little bit last time. I know that's probably a discussion further down the road, but it is a summary report, yes.
So I was one of those also that said at the time of the report, and I'm flexible. I think it could be either way. But you mentioned earlier that the big issues, the smaller departments, not the ones being represented here. So those are the departments that aren't even doing any of the investigations. They're not doing anything. It's like Cullen said the other day, the chiefs and the sheriffs that leave and then the inmates are running the asylum. What kind of impact is that? I guess that would be my only thing. How is that going to affect y'all? Does this help your issue, or you don't even know what you don't know, I guess, is truly
That's
the
exactly
question,
correct.
right? But
That's exactly
I can
correct.
see where the large agencies, the Houston, Dallas's, DPSs, it would be very, advantageous or hard for them to do them on every time. I get that, but I just don't know.
It's, if you look at it, you've got a system with enough energy to operate itself regardless of who the players are when you get to a large agency. When you get to a lot of these small agencies, it depends on the chief, sheriff, or constable who's operating the system that week as to whether they retain anything, whether they do any of these investigations. And some of them use a scorched earth policy. It's okay, I lost an election, poof, all the records are gone. And so if all of this reporting is dependent on separation of the person plus 30, we won't see half of it. If this behavior continues. Okay?
And I think that's where on the front end, when we educate as an agency in response to these policies, chief administrators, I think that's something that's definitely, this is no longer something that you kind of have discretion when there's been a turnover for whatever reason at the apex position at an agency, that this is vital. Obviously, governmental records goes without saying, but I think that's something, a point of educational reinforcement and emphasis that we can make on the front end as well, again, in response to the policies.
We see it a lot in the new chiefs training at Lehman. We go in to speak and I walked in the office and there's nothing. There's literally nothing. We try and get field service agents out to new chief administrators as soon as we can to help them build, in some cases, the system. We don't hold them accountable. We can't hold you accountable for what occurred before, but we try and draw a clear line in the sand, help them in some cases rebuild the documentation that they have to have for us, just the 5 or 10 forms depending on the appointee. And so I think, as John said, this will certainly be trained down through new chiefs training, constables, continuing ed. We'll work with TAC, with the sheriffs, and everybody has to adopt the model policy or a policy substantially like the model policy. So we're hoping that some of those issues will be remedied.
Mechanically, to answer your question, if someone works for a 3-man department for 7 years and leaves, and at 2 years they were accused of wrongdoing that was 3 chiefs ago and that was never investigated and documented, and we don't find out till 7 years, I don't know that there will be any practical remedy for that situation.
Well, I can sure live with the after separation. Makes it pretty easy, I think.
We had talked about population, you all have given some example. I gave my examples last time. I am that small jurisdiction. My departments that I deal with that. Now, I have 2 counties. One county is less than 8,000 people. The other county is less than 40. Do we see this more in like a certain certain jurisdictions where you can say, well, look, we're not seeing it in the jurisdictions that are 300,000 bigger or 100,000 and bigger. We're seeing it in these ones where if we know that's where the problem is, because I think, yeah, everybody else that's here that's from a bigger jurisdiction is like, why are we suffering? It's not our problem. We have systems in place where nobody can really come in and, erase everything, or they were never doing it to start with. So there was never an investigation, and you're not gonna find out that there was never an investigation until this issue shows up somewhere else, and they never were able to do anything about it because nobody knew about it. Everybody, if we could maybe look at, well, where is the actual problem so that we can direct these things to those agencies and not the agencies that, well, you're putting a hardship on us and we're not the problem. It's not coming from ours. Our person could lose their election. There's nothing they can really do to get rid of it's too big of a system for that to happen. But on these little smaller ones, it's happening all the time. I mean, there's things, I'm the DA. There's things in asset forfeiture because sheriffs and DAs would do that. Oh, where's all the money? Well, they gave it away to everybody. That way the new person come in, so they ended up having to put in lame duck statutes in there to make sure that can't happen anymore. But it looks like that's that kind of same situation here. If we can identify, I think if you all have the data, this is kind of the jurisdictions that we're looking at, the size counties or size agencies that this is where that problem keeps coming up. Maybe we can narrow it down. That way we address the problem, but we don't make a hardship on everybody else.
I think that's a great point. I know certainly the data that drove SB 1445, I don't necessarily know if there was a great deal of it accumulated or presented in response to how this came along. What we can do, though, is we have developed a region map according to TICO regions, the size breakdown of agencies, one-person departments, things of that nature, how they all over the agency. And we can certainly, we're doing that. We're finishing it up right now, and we can certainly provide it to you. I think in response to, the asset forfeiture prohibitions that you discussed, that's an interesting point. That's certainly something for this committee to think about when they're talking about, are there certain types of agencies to which it would be helpful to have before the separation of a licensee? Again, this is just for points of discussion. Does a elected office, is that a turnover immediately prior to leaving office, according to the policy of this agency, to ensure it gets done? I don't know, that's a question for you all to discuss certainly, but I think that's an interesting point to ensure that at least at that level gets done. We all know that it's difficult to try to address if someone has a malintent to do something. You're never going to be able to, by policy, law, rule, statute, whatever you can throw at it, you're never going to prevent that. However, I think where it's practical in certain cases like that you brought up as well, it's something to think about. If there is a requirement, or at least considering a requirement for certain types or size of agency, whatever, however you want to bracket it, it's totally up to y'all to discuss whether or not there is instead of the separation plus 30, whether there is another triggering mechanism to submit that information to the confidential database.
An interesting way to look at that is, Chief Anderson, I know you've talked about the resources you would require to report those regularly, whereas small agencies are less likely to have the resources to maintain those files for an extended period of time with integrity, right? That's what we see over and over in our audits. So it's actually probably less burdensome for them to report them at the time than it is at separation, or at least to do so accurately.
Yeah, and that's why I like the no later than 30 days after, because that way it gives the leeway, like if you want to do it right away, have at it, but it's not required until.
I want to comment on Carlos's question because I think it's critical just for our collective conception. I don't think this is just a small agency issue. I think I'll be very vulnerable. When I first became a police chief, I had not contemplated the need to finish an investigation if the employee voluntarily resigned. I had never contemplated that. I looked at it, I don't have to do a 40-hour plus investigation now. I just saved how many thousands of dollars? I can guarantee you there are still agencies operating under that paradigm. Small, medium, large. I would submit to you that a lot of agencies, so I don't think it's a size issue. I think it's a lack of a best practice standardization.
And I'll make that point to reiterate that. I'm sorry, Cullen. And certainly, I didn't want to give the impression that it is small agencies that we're saying. Hey, it certainly, it would be beneficial for them to have these type of policies, basically from a resource standpoint. But it's also, there's certainly no, in the information that I want to get to you all is just for statistical purposes and to see how, I think it's always enlightening to see how the agencies are broke down for FTEs across the state. But Chief Standard is exactly right. These type of issues relate to personal history statements, to backgrounds, the F5 adjacent process, everything that goes along with it. It's agencies of all sizes.
Colin?
Yeah, what you said, Chief, is right on. I mean, Sunset staff and Sunset Committee spoke to that twice about, one of the major heartburn that they had during both of our Sunset processes was the negotiating an honorable to get out from under misconduct. And that was the norm, in their opinion, that agencies were using that honorable discharge to negotiate out from under exactly what you said. I don't want to spend time, resources, and energy to do this investigation. If you'll leave, we'll just part ways, you become someone else's problem. And that was the heartburn that we heard both from the elected officials, but also that was really, Sunset staff made a lot of hay with that when, and I think that was the KXAN or one of the local, the bargaining the badge was the title of the series of pieces they did.
Jason, then Victor. I saw both of you. Jason.
I'm good at it.
Oh, okay, Victor.
I just want to say, if you have a situation where an employee chooses to leave, just to be straightforward here, your capacity to complete that investigation is going to be limited.
Agree.
So this whole idea that you must complete the investigation, that's kind of falsely placed here. If the employee stays, when he leaves, he takes with him our ability to compel him or her to give his own version of the situation. So I just want to put that out there that when someone leaves.
And we discussed that during the legislative
Yeah,
stuff.
but there's a flip side to that that was discussed, which is the officer side, which a lot of times they would be more than happy to engage in the investigation, but they're not given the opportunity. And so this definitely, the compelling an investigation is something that benefits the officer as well. There's two sides to
And
that.
even if it's difficult, still try. And if you say, I tried to talk to them and they gave me nothing, that's totally fine.
And I think it's important because I've done that. I've continued the investigation after we have separation, but at least there's something documented, whereas.
I don't argue against any of that. I'm just saying this whole
It's gonna be
notion
tough,
that you will have a completed investigation.
Yeah.
That's kind of falsely
Yeah,
placed
it's
here.
not actually completed.
That's not accurate. And I don't know what I will do in a situation where the guy leaves and I say, I can't complete the investigation. I'm gonna tell you, I can't complete the investigation.
Yeah.
Just kind of.
It's the way you phrase it. I think it's still a completed investigation. It's just, you completed
It's
as much as
completed.
you could.
That's right.
Yeah.
But it's not, but again, I just want to make sure that we're clear on this.
And I think that's something that could maybe on that summary report be, couldn't complete because of, couldn't get a hold of this, that, whatever the case is, and the perspective. Again, let's look at it from the perspective of the hiring agency. Okay, they couldn't complete the investigation. Okay, what's the pertinent information I need to know in order to hire or not hire this person? They tried to complete it. That's fair enough. I understand how it is. Oh, because they couldn't get a hold of the complaining witness, or they couldn't get a hold of the licensee, whatever the case is. So that it puts it in context. So whatever that next agency.
No, I understand all
yeah.
that. I'm just saying, this whole idea of a requisite to complete, even if the guy leaves.
Sure.
Or the gal leaves, I just think we need to, going towards that, I think we need to be clear about that. That may complete may not mean the same thing.
Reasonable diligence to obtain the facts, I think, is what encompasses that.
I think we burn your computer.
But that needs to be in that summary, right?
Right.
Because the agency should consider if you refuse to provide a statement to the agency, or like Jennifer said, he had the opportunity to, and he did provide a statement, was able to clarify. When I was a robbery sergeant, everybody you arrest for robbery, you better bring them in and try to interrogate them, if for no other reason than for them to tell you you arrested the wrong guy and keep you from making a false arrest. That's what I told my detectives. This should be no different. You should always reach out and give them an opportunity to tell their side. If they choose to, great, you document. If they choose not to, then you document their refusal to cooperate. You can't.
I'm good with it, I'm saying, when he or she says, I'm out, then, and I'm not talking to you anymore, whatever, then you're done. You know?
I think
Right.
your issue is managing expectations,
Right.
understanding.
Right.
what it
That's
is
right,
means.
that's right.
All right, so I'm gonna give a quick readout, and then I'll give this to Steph in a little bit, so when we come back from lunch, we can contemplate this. A summary report of an investigation of serious misconduct that resulted in suspension, demotion, or termination shall be submitted to TCO within 30 days of separation of the employee or upon completion of an appeal. An agency may elect to submit such summary reports routinely after the completion of an investigation and any related appeals. Does that reflect what we just discussed?
Not exactly.
What I missed?
Well, you said once completion?
Shall be submitted to TCO within 30 days of separation of the employee or upon completion of an appeal.
So it could be after 30 days if there's an appeal still in process.
Right, okay, I see what you're saying. So, yeah, I mean, because some appeal process, yeah.
Right.
I see what you're saying.
Or an agency may elect to submit such summary reports routinely after the completion of an investigation and any related appeals. It gives you the option, it gives you the buffet that y'all want.
I agree conceptually, but I'd like to work.
Yeah, we're gonna wordsmith everything to death knowing this group, but this at least gets us on the board. Good?
Concept, fantastic.
Good. Yeah. All right, Iris, what do we need to do now?
Say nice.
Easy. All right. We good? All right, let's pause and everybody take lunch. I will give this to whomever, get it done. Thank you. Now we everybody's on the same page and has a vote on when we can meet. And then we'll jump back into the script. So, I do think we absolutely have to meet again before the end of the year. So I will start the bidding December 4th through the 8th. What says you all?
We have our commission meeting the 6th and the 7th in December.
6th and 7th, okay, so what about the December 4th, a Monday? Is it really gonna be that easy?
That was the problem last time. It's good for me.
And you're not this time?
It's good. It's good.
John, you,
No problem.
do you have a
It's
question?
gonna be this kind of setup, right?
Yes, sir.
Nothing virtual,
Nothing virtual.
everyone here.
Right. By the way, this is John who spells support S-U-P-P-O-R-T. He thought it was appropriate to spell it out when he told me what the email was. Y'all meet John. Great guy,
Good speller.
great speller. All right, so.
December 4th.
December 4th. Going once. Robert, good with you?
Absolutely.
Am I missing James?
He'll complain, but he's fine.
All right, December 4th at 10 a.m., Iris. 10 to 3 will be our next meeting.
Chief, is that good for you?
It's good for me, I can see it. All right, so we left off with this tentative language. Jessica said she's already gonna hatchet it all up, but this at least gets us on paper. So take a second to read it, and what says you all?
Again, we're just conceptually,
Yep.
are we good with it?
Just consensus, not commitment.
Only question I have, and it may be getting in the weeds, do we just need to specify this as for administrative investigations rather than the criminal investigations, or is it already stated in that policy well enough?
That's a great point, because in criminal, you could,
Is that the time
Moving
of
our
filing?
law.
Yeah.
okay? Other feedback?
Yeah, a little bit. About this resulted in suspension, demotion, or termination. So all the reports should be coming in whether they result in any action or not, correct? The misconduct investigation reports.
Sustained or not.
Yeah, so
Consider it something
Jennifer,
important.
this is teeing you up to talk, differentiate between the personnel file and this. Is this, or even TJ, is this gonna be a separate, the personnel file is one what do I wanna call it? It's a repository, I'll call it a repository. Is that one thing versus the personnel files and this? How's that gonna play out?
Or are you asking, I'm just making sure I understand his question. Are you asking whether or not the serious misconduct results in suspension, demotion, or termination, that would still be reported regardless? Is that what you're asking?
Yes, I suppose. So under our flow chart, all of the misconduct investigation reports end up at TCOL at some point. And this statement right here is just, it says the ones that resulted in demotion, suspension, or termination, right? And so are you making a distinction between the types of reports when they're going to be submitted to TCOL? Or were you intending that all misconduct investigation reports are submitted within 30 days upon separation?
It might simplify it to take a step back, because all you're talking about here is investigations of serious misconduct at the time of separation, right? When that separation occurs during the investigation, which are separate from all the other ones, right? And I think what they anticipated here, because they're giving you a probationary period at your next agency of 45 days, is that within that, at the end of that 30 days, that agency that hired you without knowledge or the conclusion of that investigation will be given some information which they can consider and still separate you during that probationary period. Does that make sense?
Yeah, but it's
That's not quite what I'm saying.
Yeah, he's saying something
I
different.
think if we could go back to that spot you just had up there.
Text?
Yeah, if you, instead of said the summary report of an investigation required under the previous section, instead of spelling all that out again, so you're talking about what trips the investigation up here.
Yeah.
And so any outcome of that investigation, pro, con, action, no action, inconsequential, ultimately gets reported.
Yeah, so my question back to Aaron though was this. Are you gonna have two separate databases? One for sustained misconduct, that the committee's already defined, and the other one for all personnel folders? So that I, as a hiring entity, if I wanna look for your misconduct, I go one place in TCOL, or if I want everything, I go to personnel folders.
I don't know that I can answer that question, but I don't think it's required under the law. It'll just, whereas for the agencies, they will have the two separate files. TCOL will just have potentially just the one file for an officer, where all that information will be held. But it's potentially something that could get created. It might be more work, but I wish Jessica was here to maybe weigh in on that.
Your rewrite would say a summary report of all investigations of serious misconduct regardless of disposition will be reported to TCOL.
Right.
But
So
only
basically-
only upon termination.
Right.
Or separation.
But yeah, that's just when it's due, right?
Yes.
So yeah, I think taking out, and I like kind of what Colin was saying, if he said summary report of a required investigation of serious misconduct shall be submitted. So if you take out that through termination.
I did. I just said a summary report of an investigation of serious misconduct shall be submitted to TCOL within 30 days. Yeah, regardless of disposition. We're probably gonna need to script it a little bit more,
Yeah,
wordsmith it a little
sure.
more. Because if I'm a brand new chief, I'm like, I don't even understand that, but I get it, because I've been doing it a while. Okay, got it.
Okay.
It's a good catch. John, can you make that change right now? Take out where it's after misconduct, take out that resulted in.
I can't, because this is just straight like saved in there. I would have to pull up.
John.
If you send me the corrected one, how you did.
Serious misconduct.
Where would I send it? Support SUPPORZ?
I think that we get it, and the question was, do we agree with this concept?
I don't know, yo, do we?
I agree with the concept with the understanding that words need to change.
Good. All right, so I'm gonna send this to John one more
I mean,
time.
I'm not the only one in the room, so.
Yeah, you are.
I'm sending the support. All right, hang on
James,
just a
what do you
second.
think? Okay, thanks for that.
I agree with this.
Y'all are gonna wordsmith it afterwards?
Yes, I will.
I'm not sure I understand the or upon completion of an appeal, does that contemplate that it would extend beyond 30 days, that they wouldn't get any information? It could be 2 years before they got that information?
I've never seen them last that long, but it could be definitely a year. TMPA probably could speak more to that.
Oh, do we?
Yeah.
Yeah, we got shit dragged out a long time.
Really?
So I have a question, and I'm for the 30 days in the end, but, and I agree the deal with the appeal. I totally agree with that too, but are we okay with that in the law? Because the law says 30 days.
I thought the intent was if you left under allegations of misconduct, that your next hiring agency would get at least some information to make an informed decision. And I understand that that could change down the road. All of it could change down the road. It could change years down the road. But I thought that this section was intended to give you some information on that initial investigation.
We have to do something inside the 30 days. Doesn't matter about the appeal part.
They're compelling you to conduct a criminal investigation in a limited amount of time and an administrative investigation. They're narrowing your window well within what 143 gives you, right?
Whether there's an
It
appeal
says
or
not later
not,
than 30 days after separation. Doesn't say, I agree with the appeal deal, but the law does say the 30 days.
whether there was an appeal or not, or whether that would change it or not, let's say it was never sustained. Let's say it came out, it was appealed, and it got reversed. It shouldn't be there. There would have still been an investigation, though, that would have been reported. Maybe it still needs to be reported, but maybe marking off that at the time of this report, we're aware it's under appeal, or we're, just that way, whoever's gonna get to look at it, that next chief that's hiring can say, well, I'm not gonna give it any, I'm gonna treat it as though it's not even just something I can look at, because I would have had other things to look at, but
It's not finally sustained, in other words,
right.
at this
Just so
time.
that they know it's not, it's something,
But a lot of times, if it does take that long and it's an arbitration, it's because they're waiting to hopefully get their job back. So, for them to go apply to another agency, I mean, I don't know how often with those.
They can, and they do.
They can, okay. And then in hopes that they'll quit and get their other job back? Is that something that you see?
I think the key is that none of this prohibits the chief administrator from hiring anybody, right? It's just that it gives them information that they can consider.
Yeah, it just would definitely need to be noted that it's not sustained until it is. So if it's on appeal,
It's on appeal.
yeah, it's on appeal. It's not a sustained complaint or investigation.
So what y'all are saying is remove the appeal language, make it the mandatory 30 days, and the department would just reflect that the matter is under appeal, but we're still providing it pursuant to law.
And I expect Jennifer would want them to update the record based on the appeal at some point, right? Because that record will continue to reside there. So if it was changed later, that initial report would have to be updated based on whatever the outcome of the appeal was.
Yeah, and it would
But then
just,
someone hiring in the meantime has at least the initial information to consider.
and
Then how do
noted.
they get notified that some new document's been uploaded to TCO Share?
Yeah, so that process gonna look like.
Yeah, they're gonna have to be notified properly. not just
Right,
this was thrown in there and they may or may not have seen it.
They shouldn't be relying on TCOL to maintain their record. You want to hire someone that left Houston Police Department under investigation. Within your 45-day probationary, she's got to tell you the completion of her investigation, what the outcome was. A year from now, they arbitrate, it gets dismissed. That's not relevant to you. They're still working for you. You considered it. But if they'll even go somewhere else, now the record's been updated to show the actual outcome of Houston, not the initial report that she made that you considered, but that the arbitrator overturned that decision, right?
And at the end of the day, as the hiring agency, I just want to know that it's being investigated. I don't really care. I mean, I do care what happens in the end, but the purpose is for me to make a good hiring decision. And so knowing about the investigation.
Yeah, you see the flag, so you know you're gonna contact that agency and see, hey, what's going on? What's the deal here?
But then at the final conclusion, if it's 6, 8 months and they're with HPD, and then they go, oh, it's sustained. What's HPD's position then? Well, they've been a good officer for 8 months here, we'll keep them, or do you have recourse then to dismiss them? Or, you know, what happens then?
I lost the thread. Am I the hiring agency or the?
Yes.
Yeah.
So I'm leaving Dallas, I'm under investigation, whatever, and you see it and everything, but I got a pretty good thing. You go ahead and hire me. But I got this thing hanging over me and it drags out 8 months, whatever. But I'm with HPD.
I would have asked a lot more questions than just to hire. And it's only part and parcel of the total package. So it's just one more thing for me to consider. And if it's sustained, it depends what it was, but.
Sure.
Okay. I just want, that leaves it to the agency, which I'm good with. This is what I want.
Right, and at the end of the day, it should be on the agency to do a thorough background to determine whether or not it's a good
Should
hire.
have done it.
No, but she's right. The goal here is just to make sure the information was available to be considered. That 45 days is in here. I think it expires at 45 days. You know that when you make the decision.
Yeah.
You're only going to get whatever you get within that time.
Okay.
Dan?
The 45 days that TJ is talking about can actually be extended. It says at least 45 days. So there could be provision saying, or if pending the outcome of an appeal, you can have that provisional period last that long, potentially. Something that this committee could do.
I don't see changing that. I'm good with, if the department likes you and hires you and knows you maybe have this baggage, that's it.
Yeah, there's no mandate for the department to, divest themselves of you if you're doing them a good job.
What if it's an offense that would revoke your license?
They got other problems.
So then, well,
I mean,
it's
seriously.
happened before.
I mean, that's.
So if then they're rehired and then it's sustained on an offense that would revoke a license, then TCO will just step in and revoke the license
Well,
based on the paperwork.
remember, our burden for most things is conviction or equivalent. So, yes, that becomes a statutory problem for the licensee on our end. If they are subsequently convicted of a license-altering problem, then it has nothing to do, that their next employer is gonna lose them anyway.
Right.
If you hire somebody that's, got a criminally negligent homicide or something on them, that's gonna alter their license no matter where they are. But that would be separate from the hiring. Stan, I do have an answer, I think, on the database question that you had earlier.
Yes.
The way that we interpret the bill is we got to build 2 databases. One's the public facing, which is very generic, has PSR information. The other, in total, is confidential. And so that includes the personnel files, when the whole personnel file comes up at separation. That includes TCO records, which would also include the stuff captured under 4522, and then out-of-state post records is the third component. But that's all behind the wall, if you will, is confidential. But it should be one thing is the way we've got it parsed for design.
Okay.
The only other thing would be if we make entries into the NDI, National Decertification. But all of that would be captured in the confidential protected database. And so any query into that would have to come from a potentially hiring or appointing agency. And that's again, protected from the public disclosure.
All right, so what about this? A summary report of an investigation of serious misconduct, regardless of the disposition or findings of the investigation, shall be submitted to TCOL within 30 days of separation of the employee, period. The agency may elect to notify TCOL that the matter is under appeal, period.
No, I think they should have to.
Yeah, they shall.
Shall
They shall
elect.
notify.
Shall notify?
Yes.
It could just be a checkbox on the form or
Yeah,
whatever.
that's what.
Yeah.
That if, shall notify TCOL if the matter is under appeal. And if an agency may elect to submit such summary reports routinely after the completion of an investigation.
We want to add that if it was under appeal, they need to update the record with TCOL based on the results of the appeal.
Whose responsibility is that gonna lie? I guess that's the question, because if they're gone,
Well, the agency
It'd
would.
be the agency that's conducting that did the investigation. If it gets overturned, it would be their responsibility.
I think there's two options. It's either we notify that it's under appeal, the agency notifies it's under appeal and then notifies the final outcome, or there's an amendment if there is a change in the final. I think it's one or the other.
Well, if you checkbox under appeal, there's gotta be a result at the end. They gotta notify that the result.
and within a certain amount of days too.
Yeah, sure. Absolutely.
Colin, are y'all still looking at doing one of this, like Jessica passed this form out to be, for updating this kind of stuff?
That was just kind of to visualize it, so, yeah, it would be something akin to that, but it would probably be all resident, fillable online.
Okay, so I added a sentence. The agency shall notify TCOL of the disposition of an appeal within 30 days of receipt of the decision.
But why are we doing that?
Because
So-
if the form that's submitted says that this is currently under appeal, there needs to be some notification that the appeal has been resolved and then now here's the final disposition.
Not necessarily for, if you're the one that hired them when they were under appeal, not necessarily for you, although you could access that information, but if they go again to another agency, now it's in their file. And it's in their
Yeah.
completed file that that's
That's closure to that case
particular. Yes.
on the subsequent appointment.
That makes sense.
And also you, as the person who hired them, could access that if you needed to, like maybe they got in trouble again or something and you wanted to know
That same
if
information
that's
in
staying.
there.
And remember, under 4535, any licensee has the opportunity to respond to any negative document that's in their file within 30 days. So they would have an opportunity to respond that this is under appeal and the reasons why, right? And so at some point, we're gonna have to incorporate this in rule, and we should add a provision that allows them outside that 30-day window to add a subsequent ruling in case the agency doesn't, right? If the arbitrator finds in their favor that they could add that directly.
Okay, so either or could do it or both.
That would need to be in rule at TCOL because that 30-day window is established in law here. It doesn't prohibit us from adding it after. It just guarantees them the right to do that within 30 days.
So are we gonna be continuing to duplicate this information? So in this instance, the matter's on appeal, we send it in, they leave the agency, go to another agency, right? The agency completes the appeal, they upload that information. The employee then leaves that second agency, and then their file is uploaded again. So are we gonna have this humongous line of the same thing over and over again? We continue to do the submissions, because it'll be in the appeal or that investigation from the now new hiring agency will be contained in there. Hopefully they'll have the information. I don't know, I'm just trying to visualize how this is gonna be the same report over and over and over again.
I don't think if agency one did the investigation, they're responsible for all of the records involved with that investigation. Agency two wouldn't need to submit anything regarding that investigation that happened from agency one.
So you're gonna hold agency one responsible for updating a file of an employee or a person that used to be an employee, no longer with me, I don't care what he does anymore, but you're gonna hold me responsible to maintain that file?
Not maintain it, but update it if there's an
That's
appeal.
what- That's maintenance, that's maintenance.
Yeah,
Then
because if there was an appeal process afforded by that political subdivision, then that's, the result of that belongs in the file. And now
I
TCOL's
don't
saying,
care about the file anymore once he leaves or she leaves. So why are you holding me responsible?
Well,
Yes,
because
you
it's the
have to
political
carry.
subdivision that has the file. I mean, they're responsible, I mean,
Correct.
city
Yeah.
manager and HR director can chime in, but they would be responsible for,
We're responsible for maintaining the file for a certain amount of years, 5 years for 143, and then it can be disposed of. So we have to keep it anyway. So I get that. Yeah, I get, we would just, basically, we're adding a piece of paper to a file that exists for an employee that's no longer here. I don't like it either, but
But that's
that's
also
what it is.
the reason why that we're having the conversation, because of the wandering officers who bounce from place to place to place, and the firing agency is like, not my problem anymore.
exactly,
So
it's the
this
follow-up.
addresses that, not my problem.
I answered my own question.
Can I add to your own answer? Because
Okay, go ahead.
we haven't figured out what it's going to look like, and that's part of what we're looking at, is avoiding duplication of records. Certainly in your background, you're going to include what happened at the prior agency, your documentation of that. That background should be available to the next hiring agency.
Well, yeah, no, I definitely want to see it. No, I agree. I
So
absolutely agree.
There will be some duplication of records. No doubt, some agencies will send some things. 3 chiefs later, when they separate, they're going to send us the entire file, which will include things that we've already received piecemeal prior to that. So we're trying to figure out how to structure the database.
Yeah, and I guess that was more my question. If I submit after every investigation, if I have the ability to do so, and it goes, and now that
Snowball
employee
effect.
separates, then I send the file that's got the same stuff that's already in there. So, yeah, that's a clerical issue. I get it. You'll get to figure that one out. I just don't want to read it over and over again.
If we're reporting everything, then why make a distinction? Why are we cutting lines as to sustain, not sustain, all that kind of stuff? If we're just reporting everything, why don't we just blanket everything?
That's what we did. We took out the language of it having to be sustained. It all gets reported now.
And, you know, and that's unfair to the officers. That's unfair to the officers, for those people that want to build. That's the whole reason, that's the whole reason 143G got created, was to protect those officers from false accusations and from the opportunity for people to basically construct bad case files of a person.
But that paradigm exists now. If I'm gonna go hire a Houston police officer in their civil service, I'm gonna send my background investigator and I'm gonna review their G files. It exists now.
But we lost G files here 2 years ago. So that's when we lost it. Okay, we lost it to here. And there is supposed to be a certain restricted access held only for the purpose of, it was loaded up for and no more. Now, here we are, and we're saying, just put everything on there and give it, never ending, never expiring, and give it up regardless. So I'm gonna be able to complain 20 times on Officer X and 20 times on Officer Y, and man, the next time I'm gonna look at that applicant, man, they got 20 complaints. Sustain, not sustain, okay, but what, 20 complaints?
No, because these are only serious misconduct.
Well, that's not what we said earlier, but nonetheless,
Well, and
that's okay.
I see your point. I would rather not have to send a TCOL documentation that says, hey, we investigated, there was nothing here, but the legislature said we kind of have to.
And that's why we try to define what is sustained, and limiting sustained to the things where we have little or no boundary, and that is terminations, suspensions, and whatever that third time is.
But again, this is only serious misconduct, and I understand your concerns with that, but also upon termination is when it's due. So, separation, or, yeah. So, I mean, it's not the volume of it, is it?
I'm just saying, you know, I'm thinking about that one officer. It's being fair to that officer, because there can be unfairness in the process.
But what we see is the unfairness is in the lack of investigation. Because if there's an allegation out there and there was no investigation done, that's gonna look really bad on that officer if it's not true.
But
if there's
it
an
also goes,
investigation-
it also goes down to that, back on John's yellow chart. Submit summary report to TCO, including dispositions of investigations on all other investigations. So it goes back to what y'all said. Whether it's this serious or not serious, whatever the issue is, we still have to send it to TCO, no matter what we've done on anything.
We're creating A and G files for TCOL.
Yeah, I think if we're narrowing it to serious, which we did earlier today, then that's all that ever comes. It's sustained, unsustained, basically, is what we're driving at. We would have, here's a complaint, here, investigation, unsustained. Here's a complaint, investigation, sustained. All of that would come at some point. But the other, kind of the disciplinary stuff that you talked about, tardiness, uniform requirements, those things would not, because it's not in the misconduct as defined, or the serious, misconduct.
Well, that's not true. I mean, to some extent, we've still yet to construct what the personal file is gonna look like and what you're gonna get when they leave. So some of that's gonna be there, but
Yeah. As John said several times, we're not going backwards. Agencies consider that information now. If they come and you have written reprimands or oral warnings documented in the personnel file, the agency looks at that and considers that. That will have to continue to be reported. What the may suspend, demote, serious misconduct, all that is the trigger requiring an investigation. That's what's important to remember is you cannot choose not to investigate those things.
And the A and G, like you were saying, I mean, the difference is, I agree with what you're saying, but the difference is this is none of this is available to the public. We're talking about, right now, we're talking about this confidential database, and John described to us last meeting how that is confidential and why, and there's more to follow, like we got our ruling on that opinion that I was telling you about that went in our favor and the officer's favor. So, this isn't about what the public gets to see. This is strictly about the prospective agency, which is a big difference.
And you're not creating a file. It's a file that already exists. It's just where it's going to be stored. It will be stored at your agency and additionally in the
I was making a joke.
Yeah.
Well, sadly, it's not a joke.
All right. Support John has again uploaded our final statement. I say that jokingly. So take a look at that and see what you want to change.
I might want to change all of it, but not today.
Spoken like a true attorney. All right, can we get consensus? We're not to commitment yet. Anything that just jumps out there, like, I can't live with that.
Does this address the criminal stuff that you raised?
Well, I think so, because of the,
Is it possible that on our model policy, we have a whole separate section dealing with criminal?
maybe that's what we ought to do, is so they don't get confused, have the requirements for a criminal investigation, the requirements for administrative investigation. Just
Okay,
kind of
so-
like this little chart.
So help me understand, why do you want to bifurcate, so to speak, the criminal from the administrative? In my world, if we have an officer under investigation for criminal, we're going to have a separate but concurrent investigation, and we're also going to have an administrative. Regardless of which ones those, I'm still going to do some kind of disposition.
Sure.
What would I do different in this process if it were criminal?
Sorry, go ahead.
Yeah, I was just gonna say, it's, the biggest part, and y'all tell me if I'm wrong, is that the submitting at the time of filing, you're filing the criminal charges. You've got, there's no 30-day window there, it's immediate.
Yeah.
So I think that part has to be, there's the one significant difference.
If there's an arrest, yeah.
We already have the, what we call the E1 process where, so this doesn't alter the E1 where the licensee has to report an arrest or indictment, the arresting agency has the duty to report, and the appointing agency all have a duty under the current rules, longstanding, to report that criminal arrest, should it occur. So this doesn't alter that. And I kind of arrived where Stan did, is you can have a separate, distinct, it should have, in my mind, a separate and distinct administrative investigation. You can terminate, suspend, or you can terminate somebody with unadjudicated criminal conduct.
Right.
The DA doesn't want to take it for whatever reason. You, the chief sheriff or constable, can divest yourself of that employee because your administrative investigation says this conduct more likely occurred than not, much lower burden of proof, and you can get rid of that employee for that. And so that's the investigation that I see coming in this stream into this database. The criminals doesn't have to,
Well, I just didn't know, do we need to address that, the criminal side, since it's addressed specifically here in the law?
I think
I think it's a valid question, but from what I'm hearing, maybe not. that accurate?
I prefer to, yeah.
I mean, can you just say like notwithstanding and then cite the section? This all applies, and so does the section that already, I mean,
Well, I think.
because they're not mutual.
I think it's, you know, if you go back to the original allegations, it's alleged criminal it's not the adjudication of crime in the courts process.
Right.
It's if I accuse an employee of theft by a public servant, the county attorney, DA may not be interested in the case because there's some, ambiguity, but from our standpoint as the chief administrator, we're gonna run the administrative track and they're gonna find their happiness elsewhere.
But to Jennifer's point, we'd be well served by referencing the E1 process in our policy, just to remind agency heads, hey, don't forget you also have to report an arrest.
And I'm sorry, and that's what I was suggesting, just
Yeah.
a quick note about that so people know about that side.
I got it.
Not two completely separate tracks for investigation.
I like what you think. I thought it was Jennifer, but if it was TJ. I just need to know what specifically do I need to look up in policy, that E1 that you referred to? Where do I find that in statute?
It's in rule, but I think we need to look at C and D in here because we're talking about different things. And E1 is triggered by the arrest.
Right.
Subsection C is triggered by the completion of an investigation, regardless of the outcome, I believe, of a criminal investigation. And I think what you're talking about is important, that most agencies bifurcate. They complete the criminal investigation, and some of them stand by on the admin investigation until the criminal is complete, or the other way around, but that you're going to have separate timetables based off whether you're under subsection C or D. In this, it's under 4522 B
One,
1
C and D.
C and D. So the E1 is even separate from that.
Right. So Dennis, I'll try to wordsmith some language between now and our next meeting. Or actually, Jessica will, since she brought up this whole mess.
Well, I agree down here that it doesn't have to be two. I think it's just a couple phrases.
Right.
Just- Yeah.
But you just said very clearly, depending on C or D, there may need to be separate timelines.
For E1.
Right. Well, just for the E1, yeah. But that's existing rule anyways.
Correct.
Yeah.
Are
But
they
you
all
could-
together in the same part of the code? Those, or are they all? over
C
the
and D are here, but
The E1 is, so what he's talking about is in the misconduct section here, which does not include any of the E1 stuff. The E1 is in rule, right? All the E1 requirements are in rule. DJ, is that correct?
yes.
Yes. And so he's reading the rule that, or the statute in here, that there's two separate timelines, or the potential for two separate timelines here in the misconduct investigation reporting scheme here. Do you want me to just read it out loud?
Yeah.
Okay, C says, report an investigation into alleged criminal misconduct for which criminal charges are filed against the license holder to the commission in a
That's
timely.
the key right there, for which criminal charges were filed.
Yeah, that's.
Criminal investigation, no criminal charges filed.
Right, and so that would fall into the next one. Let me finish here. Okay. Report an investigation into alleged criminal misconduct for which criminal charges are filed against the license holder to the commission in a timely manner after the investigation is completed. D says, complete an administrative investigation of alleged misconduct and prepare and submit to the commission a summary report on the investigation, including the disposition of the investigation and any informational findings in a format prescribed by the commission in a timely manner, but not later than the 30th day after the date of the license holder's separation from the agency, if applicable. So that's where he's getting those two potential different reporting timelines depending on the type of misconduct investigation that is happening.
And that still argues 3, because the arrest doesn't mean the investigation is complete, right? Certainly someone could be arrested, you could report that arrest, and it could take 3 months before you complete the investigation, and then you have a reporting requirement under C.
So the C, how quickly do we have to report to the commission on the criminal?
It just says in a timely manner, so that's what part of the charge for the committee.
If a criminal charge is filed.
Yes, so that's kind of how we have it on the flow chart. We have,
Oh, thank you.
I thought it said when the charges were filed.
30 days.
So let me ask this question. Officer X one of my officers gets arrested in Houston partying or Houston over there, partying out there, gets arrested for DWI. That's a charge, a criminal matter, all that kind of stuff. I just want to be clear because we keep saying criminal investigation. Am I now going to have to conduct a criminal investigation about something that happened in Houston?
No.
That's not clear.
You're doing
Just saying,
administrative.
that's what I'm asking. So are you saying criminal misconduct, criminal charges, investigate, report?
I think you're doing an administrative investigation
Yeah, I know.
into
Yeah,
the
yeah,
crime
yeah.
that occurred in Houston.
Right, and my whole point is this, when I do an administrative procedure against an employee, if it involves criminal misconduct, my standard is not proof beyond a reasonable doubt.
Correct.
That's a standard for a criminal court's jurisdiction. So we're moving into this criminal stuff, and if you do this and you suspend them or terminate them for criminal stuff, my standard is not proof beyond a reasonable doubt.
We're just talking about when to report an investigation into alleged criminal misconduct. We're not,
Right, and that's what I'm asking. So my officer gets arrested in Houston, there is alleged criminal misconduct. Am I now required to report it, investigate it, and all the kind of different things? Other than what we do now. We report to.
you're required to report an investigation into alleged criminal conduct.
So I'm not required to investigate.
How could you?
Actually, it says, let me go to A,
Jurisdiction.
because this addresses it, Victor. Under A, it says, the policy adopted under this section must require you initiate an appropriate administrative or criminal investigation into alleged misconduct of a license holder employed by you at the time you become aware of the alleged misconduct. So yes, you have to initiate the investigation.
I'm fine with that. I'm just talking about the criminal misconduct.
I think that's Houston's doing that.
Talking about criminal.
Yeah,
Houston's doing the criminal, you're doing the
criminal. You
administrative.
can't do a criminal investigation and
Right,
so
right.
you don't have the authority.
Because it says or administrative
It's-
or criminal.
And that's like what TJ was saying, is sometimes you have it on hold until, you're pending the criminal outcome in Houston.
Right.
You're gonna, put your admin investigation on hold until you get those results, so. But you would still conduct it, you're just waiting for the actual criminal investigation.
Dan, you wanted a rule reference?
Yeah, I need the citation for the E1.
21127 is the individual's responsibility to report. The agency actually falls under 211.28. Responsibility of law enforcement agency to report an arrest.
So 211.27 and 211.28?
And what's the timelines for those? Are they the same for the individual officer and
Days on all of them.
30?
I think it's 30.
How do
what, an
y'all,
arrest?
without getting in the weeds too far, how do y'all, like the chiefs over here in Houston, troops in Houston, how do they know he's a McAllen peace officer? I've always wondered, how do y'all?
A lot of it, go ahead, TJ, you run.
We don't generally enforce that. I've got one where the Harris County Sheriff is on TV talking about how this constable did this and this, or deputy constable. So clearly they knew. If it's in the affidavit, if it's in the report, if they were identified at the time, they should have reported.
Sure.
The appointing agency has, you got to remember in a lot of cases, these people aren't appointed with any agency, right? So then it's only on the licensee. We're now using RATBAC more and more. People are getting fingerprinted. We're getting those reported electronically. So the need for that is becoming less. I just don't want to. Most of the failures that I see in enforcement by agencies across the board are a lack of knowledge and it's not an intent. And so if you can put it in their policy where they're far more likely to read the policy than they are 211.27 or 211.28 or 1701, right? Where it says we have to do these things, especially the chiefs and the smaller agencies will get it right. They'll have a fighting chance. So that's my only point is put it in there. If they don't know, I'm not going to try to hold them responsible if they didn't know the person was a peace officer. It's just, that's never been the intent of the rule. But if you're on TV talking about how this person was a police officer and embarrassment, you didn't report it to me, then yes, maybe we have an issue. I think it is important to talk about that's triggered by arrest. So conceivably, people can be charged with a crime. The investigation could be complete for months before that person is arrested.
Yeah.
That these timelines can operate independently. Most of the time, they will be concurrent, but they could be independent, so they need to be cited in separate sections.
So I dare hazard to ask this question, what do we consider a timely manner? If a criminal charge is filed and there's not a concurrent arrest? Because if we don't put it in model policy and we just say in a timely manner, then everybody's gonna interpret that differently.
So I have a question again?
30 days.
So existing law requires, and by the way, this is
Consistent.
1701.4522. Existing law requires report and investigation into alleged criminal misconduct for which criminal charges are filed in a timely manner after the investigation is completed. Interesting that they actually put after the investigation is completed.
So what's the question?
What's a timely manner?
30 days.
30 days? I would live with
Keep it
it.
consistent.
Especially if it's, like you said, Chief, it's completed, so why would you need
I agree.
more time than that?
And the 30 days in the E1 starts at arrest or charged.
Say that again?
I said that the 30-day reporting clock for an E1 report starts at arrest or charge. So if you charge, filed a charging instrument, you would start the 30-day clock.
Got it. All right.
So let me walk this through real quick. Officer gets arrested in Houston, DWI. I've got 30 days to complete the related investigation.
No.
So what are you saying?
You got 30 days to submit the completed investigation.
That's what I'm saying.
You can take as long as you want on your investigation.
You have 30,
You need 3 months, you need 6 months, you want to wait 2 years until the criminal's resolved, you can do that. But then, once you've completed your investigation, you have 30 days to submit it to TCOL.
And or if the criminal case is disposed of, you have 30 days to submit.
Okay, so just to be clear, officer gets arrested in Houston. I get notice. I've got 30 days until when? To notify TCOL of my completed.
E1, you have 30 days.
That's true now. If one of your people gets arrested and you know about it, you have an obligation right now to do an E1 30 days.
Yeah, that one we know. I'm clear about that. I'm talking about the investigation part of this. You said complete the investigation in 30 days.
No.
Okay, so what did I hear? What was it you said?
I specifically said,
No, not you, Sam. I'm talking about Chief in Houston, sorry.
30 days to submit the completed investigation. Once it's completed, you have 30 days to give it to TCOL.
Once I complete it.
Uh-huh.
So I
You can take
complete it.
6 years to complete it, I don't care. But if it's done in 30 days, when it's done, 30 days comes to TCOL.
Unless the person separates during that investigation.
Yes. Or the criminal is dropped, like Chief said.
all right, good luck crafting this.
You're gonna send me your notes, right?
I am.
Okay, thanks.
I absolutely am. All right, I want to reflect. 1701.452 is current statute. And it does not alter the E1 process, which is found in the rule, where if there's an arrest occurs, the license agency and the license holder shall make a report within 30 days to TCOL. We then talked about their separate timetables, actually specifically 3 separate timetables. Section C is going to require a timely manner if a criminal charge is filed and the investigation is complete. We all agree that's 30 days. Section D requires, this is for the administrative investigation, 30 days after separation. And then the E1 is required 30 days. Is that pretty reflective of what we discussed?
The E1 is for criminal matters.
Say again, sir?
The E1 is for the criminal matter.
E1 is for an arrest.
Criminal report.
Just, the E1 is just triggered by arrest. I don't think it's a charge, is it?
It is.
It is a charge?
Arrest or charge.
Arrest or charge. Yeah. I honestly thought it was less than 30 days, but good.
Good for you for being efficient.
Yes, we do it within 24 hours. When HPD comes to San Marcos and violates the law. All right. I think I got all of that. Looking at the agenda that Iris gave us. So does this satisfy a timely manner for submitting criminal and administrative misconduct reports to TCOL? Is there any other unresolved dialogue that needs to be done?
I would venture to say that we have enough on paper to work with. so that we can come back next time and finalize it.
If I can add just one thing, it also requires that summary be put in the personnel file. I don't know if we want to include that on the misconduct policy or the personnel file policy, but it would need to be included on one or both.
And that's
Four
where,
fifty-two.
that's where we get into all the discussions about
Well,
what that
and I
exactly
think you
is.
go back to write this one and the other one and then reconcile. Are there things we need to crosswalk between the policies? You may want to craft them both first and then look for those.
Sure.
Okay, well, TJ, do you want us to skip best practice hiring? Because that's probably not gonna be very contentious, and go ahead and knock out the fourth agenda item and talk about that very issue?
Either way, I think I probably need 5 minutes or less on mine, so whenever you want to do it.
Which one was yours?
The hiring.
What do y'all wanna do? What do you wanna do next? We have an hour and 45 minutes.
I think he's right. He can knock his.
Knock it out.
That's 5 minutes on this one.
Fire away, TJ. So we're, for the purposes of the recorded meeting, we're gonna move the fourth agenda item, or third agenda item, best practice policy associated with hiring a license holder, and I think I submitted for TJ's response.
So I wrote this, we were trying to keep it just to the bare basics that TCOL already requires, either in administrative rule or in statute. So I put the citations of where I got the information from there. I think it's certainly the purview of the committee if we wanted to go above and beyond slightly to the bare minimum requirements we could. Nothing has come to mind yet, any best practices or things like that, but certainly if y'all have any ideas of best practices to go a little bit above and beyond, let me know and we can consider that. The other thing Captain Rice pointed out was this is just for peace officers. I need to, at some point, update this to reflect what is different about county jailers and dispatchers as well. I may need some help from staff on that because I know that there's a few differences.
Basically, H and I would be just for peace officers. And on item number 6, on the back, A, the physical for telecommunicators, the medical part. So
Yeah, it's drug screen only. They don't have to have a full.
those things, we were just thinking, put peace officer only on those areas. And then the only other question I had when I was communicating back and forth, and I don't want to get in the weeds, but on item number 7A, we put by properly licensed psychologist, psychiatrist. I didn't know if we needed to put, is properly good enough legal term, or should we actually put what the statute says?
Yeah, one of the things that we get jammed up once in a while, we get it remedied. They must have a license to practice in Texas. So it's very
So
specific.
go ahead and put the specific verbiage there.
Yeah, I would recommend that. It just takes some of the, helps us on our intent.
So should it say properly licensed or licensed in Texas on this one?
I'd have to look up this, but they have to, in other words, an MD has to be licensed in Texas. And same thing with a psychiatrist or psychologist. They must be licensed to practice in the state of Texas. So we get calls all the time from the border going, hey, my closest psych is in Oklahoma. Well, you can use them as long as they're licensed to practice in Texas. And the same thing, we get a lot of out-of-state people and agencies recruiting out of state. They say, hey, can this guy who's in Virginia in the military get his psych there? And normally the answer is no, unless they stumble across a doctor with a Texas license.
So we have some in Mexico.
I'll incorporate that language. The technical advisory bulletin or whatever that acronym is was very helpful in helping to write those sections. So I'll incorporate that.
And just, you know, the one caveat is one of the other advisory committees is dealing with the medical and psychological. So, you know, y'all keep doing what you're doing, but there may be some tweaks we have to do in the end state when the other committee
The other thing I thought of today is about the provisional hiring period. Is that something we feel we should include in the hiring model policy?
Ours is gonna be different for every agency. For like us to meet and confer, we extended ours to 18 months.
But it's a minimum of 45 days now, right?
That's correct.
All the requirements to physically sign, I'm with, in this day and time where a lot of folks are doing.
Well, that came from the TAB. They didn't want a stamp. They didn't want a literal rubber stamp.
There's a requisite here for physically sign.
On the TAB, it talked about they didn't want a literal rubber stamp.
I understand.
So, yeah.
I'm just.
So, yeah,
I'm answering for
let me look at that.
The 40, now, is the 45 days, is that not just for a former, a licensed person somewhere else, or is that for any applicant? I thought the 45 days was just for if you were hiring, if I'm hiring somebody from another agency, I guess I didn't realize that 45 days is for anybody.
I think that was what the legislature was looking at, was presuming, go back to the wandering officer mentality that they're trying to entertain. So I don't think they're imposing a 45-day, no harm, no foul on all employees necessarily. But I think it was that, it's presuming there's something in the background that's gonna come from this other law enforcement agency, and we've given you 30 days to do that. So we're giving these guys 45 days to react to whatever you do in that 30 days. So is that, is that where you're getting in it?
That's, yes, I guess, and I may have misunderstood what TJ was saying about that. Are we talking the same thing? 45 days, is that what you were talking about?
I'm referring to somewhere in the sunset bill where it.
I can read the section.
Yes, please.
And again, Colin's right, this is talking about you have 30 days to investigate, report it to T-Cole, and then it says establish a provisional hiring period of at least 45 days for any license holder employed by a law enforcement agency, and allow a law enforcement agency to terminate the employment of the license holder if information relating to an investigation of alleged misconduct by the license holder is made available to the agency by the commission as part of the pre-employment procedures required under 1701-451A within the provisional period. So the last agency finishes within that 30 days, reports it to T-Cole, you become aware of it, you can terminate them
Only
based on new
previous
information.
Yeah, but
That's different from the provisional hiring period that you're talking about, right? You're talking about like PPO and
Probation.
No, I was talking about the
Oh, okay.
45-day period from the sunset.
my bad.
Because that applies to every agency in the state now, the 45 days. There are a lot of agencies that don't have provisional periods.
yeah.
Most of those are at will, so it's all.
I was gonna say they're at will. I mean,
Yeah,
even big cities, we have civil service, it takes 18 months for my officers to get civil service protection. They get fired for any of that. Smaller departments, all these little ones, I don't think they have any protection, so 45, that's not even.
Well, it would surprise you. Some of them have 6 months. I don't think this 45 days alters anybody who gives a longer period in favor of the employee or in favor of the agency.
Yeah.
So I think this just enforces a minimum, no harm, no foul, 45 days where I can divest myself of this person if the bad news comes in after the employment.
Sure. So include that provisional or? I thought it was already in there.
Yeah, I don't know that it's necessary if it's already in statute.
It's in the statute, but should it be in the model hiring policy?
Sure, it doesn't hurt being redundant, but that's fine.
Well, everything.
redundant on everything.
Everything in the model policy is statute
Yeah.
or administrative rule that I put together just in one area.
For a comprehensive document, you might as well just include it.
Okay.
Yeah.
Okay. Got it.
Where,
I think.
Colin, where in here are the fingerprint requirements and such in the model policy? Is that just some part of some language that I don't understand what it really means? Because don't we have to undergo temporary card?
In the model that we're reviewing?
Yes. Because you have to do it, right? You can't be licensed without it, so I think it has to be in there.
So most of section 3 is SB 24 from the 87th session. And if fingerprints weren't on that list, then no, there's no fingerprints in here. So yes, we should have that included somewhere.
And for us, it would fall under 217.1. 217.1B3. Probably. Fingerprinted and subjected to a search of local, state, and U.S. national records and fingerprint files to disclose any criminal record.
Page.
So that's the rule requirement.
L1 is, oh, you're right, it's L2, 3.
Do we need to reference the L1 being approved by TCOL? Should we reference the L1 being approved by TCOL? I think that's kind of important. Don't put them to work before the L1 is done.
Well, at least that it needs to be
That's the
submitted.
safe bet. I mean, we're getting off in this kind of ethereal, you can appoint 30 days post-appointment. I'll have to look it up. You have to notify us of an appointment with 30 days.
30 days, yeah.
You know, so you could, in theory, put somebody to work and notify us 29 days later that you have done so. We don't think that's a best practice.
Yeah.
We would rather see that, and most chief administrators want to see the clearance on the L1.
That's kind of what I was getting at, is you don't get to do anything until I get the notification from you.
I mean, that would be the best practice, but there's some statutory stuff that says you might or might not have to.
And also, I mean, just looking at the administrative code, the fingerprints are required before enrolling in any basic licensing course. You have to have the fingerprints on file. But this is for background investigations for hiring. So,
Prior to.
So
Yeah.
how many of you hire civilian employees and pay them as cadets to go through the academy?
Yes.
Yeah, pretty much
So
most of them.
that's part of what that covers,
yeah.
because that's their initial licensure.
Yeah, I'm just saying that there's a difference between me running the guy off the street who wants to be the police and actually putting him in the class. And what this charge is for the actual investigation for the background, right? Or am I?
Well,
hiring.
but then if you go further down, licensee then you get into breaks of service. So 180-day break in service, you trip that fingerprints again. So
Right,
that's another reference. Where they have to obtain new proof that the licensee has been fingerprinted and subjected to the search I described.
And the psych exam as well, only if there's over 180 days, right?
Correct.
Yeah.
So
but again, this is just a model policy for.
Right.
We
we don't have to get too far into the weeds.
can,
We can.
I don't. But should this policy contemplate the stuff that's in the admin code? Or did you already include all that, like the fingerprint stuff?
I have not included fingerprints. I have that on the list to fit that in somewhere. But most of this is administrative rule or statute.
You were gonna say something?
I think it doesn't matter where the fingerprints were done, Chief Anderson, for your scenario, they're done before they enter the academy, and then the appointment, you still have record that they were printed. They've been in your employment throughout that period. It was part of a background conducted over an extended period of time. I don't know where we would want, and maybe there are situations, but I don't know why agencies would want to hire people without doing fingerprints.
No, I agree. I'm just saying for purposes of this model policy, I don't want to talk about model policies for what we're doing in the academy or how we get into the academy if this is just geared towards the basic recruitment side. So I needed a little bit of clarification about where we are in the process for this policy specifically.
And I think you have to remember background investigations apply in both scenarios, right? If you're hiring people and going to put them through an academy and then appoint them, or if you're going to hire them and appoint them.
Right.
The same process should apply in both.
So maybe just a quick sentence to say fingerprints are required either before the academy or before.
Yeah, you could say the language we would use is for initial appointment, or after a 180-day break in service. So those are the two times. So if this is the first time this person will be appointed, initial appointment, you have to have fingerprints. If they've had a 180-day break in service, you have to have fingerprints.
And same on the psych.
Yeah, psych and physical kick in at over 180-day break.
And I would ask this group to consider whether that 180-day exemption should even apply, or whether a model policy where an agency operating as a model would print everybody who they are going to appoint.
Oh, you went there, didn't you?
We do that.
Wow.
I think most agencies do that already.
You say that again?
Yeah, exactly. You got his attention.
I believe that every agency who's going to appoint someone should have that person fingerprinted. That they shouldn't say, well, it's been 160 days since her last appointment, so I'm not going to fingerprint this person. I'm not sure why agencies would want to apply that exemption. And if you're going to write a model policy, I would just say as part of the background that you fingerprint a candidate to ensure that they don't have any arrests, outstanding warrants, any hits in NCIC, TCIs.
Okay, we already do that. The site, that's the portion I'm concerned about, because I actually had an applicant not too long ago that actually he filed a complaint because he was with another agency. We provide a psychological evaluation for everybody. So regardless if you're already with an agency, 180-day thing, doesn't even matter. And so he filed a complaint because we did the psych eval, even though he said that his previous psych eval was still good, which is true. But we don't know what he was exposed to during that time period, and he failed the psych.
Right. Again, these are minimum standards. They don't prevent you from doing those things. It's the minimum standard that you're required to meet.
Yeah.
The other committee's looking at all this, right?
Well, the other thing about it is a lot of psychological exams, which you get off in a whole different section. A lot of times, we got into this on the other committee, is this notion of Dr. A is good, Dr. B is bad, and the two disagree. When you're the chief administrator, you're the agency, you contract with a psychologist who looks at your job description and your desires and needs in an employee and is supposed to tailor that event to your agency. So you're well within, in fact, in Cullen's mind, you're doing exactly what you should be doing, is making sure that everybody you hire is physically and psychologically capable of being a Texas Highway Patrol. So it does not surprise me that someone would complain, but the notion that all psychologicals are built the same or all physicals are built the same, it's unfortunate, but it's not necessarily true. And so there are lots of agencies that do just that. They require a new psych and a physical on every hire, regardless of separation time. A lot don't because it saves them money. If I can get somebody on the 179th day and push send on an L1, I don't have to pay for those two events as the onboarding employer. You're well within, DPS is well within their rights to do that, and other agencies do it as well.
I'm gonna start. I like it.
I believe there's language inside there that actually states that if we're willing to accept it.
Right,
So as long as it stays inside there, we're good with that.
Each agency will have to adopt a policy or something substantively similar. So I think you could make yours more restrictive if you wanted to. Your agency could say that everyone is going to do it. It's just what is the recommendation of this group going to be? It's the model that everyone else is going to adopt.
But as far as that goes, isn't that gonna be up to the other committee to decide?
The other committee will have some say in that. They have the latitude to talk about what's the content of the L2 and L3. I mean, what does the mechanics actually look like? It's kind of like, they've got the breadth of interpretation on their end too. Now, their primary role is if a chief administrator wants one of their currently appointed employees to go for a fit for duty exam. But the door is open to some interpretation on L2 and L3 because the way the statute's written, it points back to this includes that pre-employment you know, so it kind of lapses into that. That's not the target focus of the committee, but it could spill over into that.
There is a subsection that references that agencies have to report failures of those tests to TCOL, which could be outside of the fit for duty scenario.
So for the purposes of this conversation, what is the current question on the table? Are we good with what TJ came up with?
I think, I want to consider what TJ said. And how do we communicate that where, hey, it probably would be a best practice policy to do it regardless, because I agree with Clifford. And had we not had this conversation, I don't think I would have sat around and just contemplated, I wonder if I should run new temporary car. I just wouldn't have done it.
Yeah.
So you all have made me better today. So I think we've got to get this in front of every chief, every sheriff, to at least sensitize them to the issue. So I guess I would ask you, it probably can't be in the policy itself, or it could be. It's a best practice. That's what TJ's asking us to consider.
Yeah, but I also don't want to get ahead of the other committee who's
Yeah, that's-
legitimately supposed
I
to be
think the
considering.
printing is very reasonable, but I think the other one, I would rather, because I know that they're really tasked with that topic at least, that I would defer to their committee as
I
far
could
as the
send them an
fairness
email.
of that.
Yeah, I don't want to get in front of them. I think
We
they
can
need
pull these-
Thursday.
Small pieces together at the end. I was talking about the fingerprinting, not the L2s and L3s.
Okay.
And I think that is a whole separate ball of wax.
Yeah.
And I think one of the things is we're saying this is a model policy, but in reality, this is going to become a minimum standard type policy because all other policies will be measured against it. So, with respect to, you know, some of the smaller age, the recurring psychologicals and physicals has come up dozens of times at the legislature. And the chiefs, sheriffs, and constables come out of the woodwork to fight that tooth and nail. They looked at it again this time for a very short period, getting rid of the 180-day window. And that's Sunset. Sunset actually won it. Now we're talking Sunset staff, not Sunset. Sunset staff thought every cop, every appointment should have a new psych and a new physical. And that's what they were pushing. And it was, you know, some of the associations pushed back saying that it's an unfunded mandate. This is, you know, painful. It's hard for us to get. We like the 180 days, and that's why it stands as it is now. So there are still people on the other side of that argument.
Just to keep us on track, we're here to talk about hiring procedures, so that feels a little bit outside the scope of what this conversation is.
Okay.
Not that it's not worthy or valid, just it's 1:30.
It was 5 minutes, TJ.
I'm sorry.
You felt miserably.
Yeah.
He's only talked for 3 minutes and 20 seconds.
Good point.
So do you have what you need to go back?
So I think we're gonna hold off on anything related to the 180-day window for psych. We'll wait for what the other committee says on that. On the fingerprints, are we gonna address the 180 or not? We're good, we're just gonna say everyone has to be fingerprinted.
Can I give you some context on that as well? Almost all agencies are now doing it through the FAST system. They do electronic fingerprints, which gives them real-time returns. It also means that they are then entered in the wrap-back system if they're not. So, for example, at Chief Anderson's agency, there's probably a bunch of people that preceded FAST that still work there. They've been there 20, 25 years. There's no system for the agency to monitor them. There's no system for other people. But if they have a new event where they get fingerprinted in that system, that's now much easier for the agency to monitor them to become aware of arrest. And that has been one of the things that we see a problem with is you get arrested in another jurisdiction, you don't disclose to your agency your arrest. That's part of what we're going to automate on our side is not only notifying that person that you failed to notify us of the arrest, but notify your agency that we were not notified of that in case they were not aware, and then they can initiate their investigation that's required by rule right now, which they may not be able to do if they weren't aware.
I mean, he sold me, but what says you all?
Fine with
I
that.
think it's a great idea.
What is the cost? Just
It's like $12.
Yeah,
so
doesn't cost much at all.
But you can subscribe to them too, and don't even have to send them the prints.
If they're in the system. But
Yes,
that's
that's
what
what
I'm
I'm
saying. There are a
talking-
lot of people who
Yeah,
are not in the system.
But yeah,
because
it seems like everybody anymore that I hire, they're in the system somewhere for something, it seems like.
Okay, so we're doing the fingerprints. I'll work on adding the language about the psychiatrists and psychologists being in Texas and those requirements, and then I'll work on updating the different requirements for county jailer and dispatcher.
I didn't see this document until this morning. I do want to bring up one more thing just for this group to consider is the personal history statement. There's language in there that comes from different agencies wanting to restructure. I will tell you that most agencies are not using the correct personal history statement form that I see all the time. They're using outdated ones that don't gather a lot of the information that's pretty critical. But the other thing is some agencies take it and they just change all the order of all the information and move it all around. If you want to allow them to do that, that's fine. I think for simplicity, at some point, you just all use the same form. It makes it easier for subsequent agencies to compare your last one to your current one, which is where we find most of the inconsistencies in personal history statements, right? Is not that we discover you did something, it's that in the past you said you did something different than what you're saying you did now. And that I anticipate at some point that personal history statement will become an online form, or that's my hope, is that you can complete that in your MyTCOL account. You can submit that to an agency. 2 years later, you want to go somewhere else, you update it and you submit it again and it's captured at that point. And so I think the sooner we can get people into a more uniform document, the better it is for everyone involved. Right now, we allow them to alter it as long as they keep the basic contents the same.
Who to alter it?
Agency can put their own cover page with their badge on it, and they can take section 1 and make it section 7, and take section 7 and make it section 2.
So you were saying
Questions to move down.
that you would like, at some point, for an officer to be able to have a statement that they're, is that what you were saying? That they can use?
He's talking about
He's
the
making
common
it unified.
application.
Just the form.
Yeah.
Like, everybody has
If
the same
you
one.
fill out a personal history statement at Austin, and now you want to go work somewhere else, you can take yours, update it, and add information,
Yeah,
send
because
it
a lot
on.
of the inconsistencies are because it's hundreds of pages and you're having to recall,
Because another agency takes the questions and changes the order and changes the sections, and I
Yeah.
just don't see the benefit
Yeah,
of
no, I
allowing
think
agencies to
that's
do that.
a
It
really
makes it
good
more
idea.
confusing for the officers and for background investigators that are comparing prior ones.
It would be easy for it to be the same. My only concern is some agencies want to go above and beyond. The TCOL PHS requires 3 references or 5, and we want 7, or whatever the case may be.
And a lot of agencies have an application that they require in addition to the
Supplement.
PHS. This doesn't limit them in any way. They can add to it. It would just maintain a consistent
This
structure.
is your baseline, and it's a consistent baseline, it doesn't matter if you're
Sure.
applying for Houston or my department. Like,
Yeah.
Yeah, but don't take that form and change, fill this form out, you gotta be done. And if an agency wants additional, that's on a separate form.
Yep.
So committee is supportive of a standardized PHS?
Yes.
Yes.
You're gonna put that in there, TJ?
Yes, sir. I'll update that language and then just say that they can have a supplemental if they want to have supplemental pages.
The only question I have on that, and I'm gonna, because I've amended ours. So I'm gonna disagree because mine, all the numbers are exactly the same, everything's the same. The gripe I always had was if you said no, or if you said yes in the top 20 items, tell why now. And I was having a major problem because they would forget that they said yes up here. So what we did is on ours, it's basically the same thing. We put, if you checked yes, tell why right here. If you checked yes, tell why right here. So the answer goes right with that, not wait until you get to 20 questions later and then answer all that. So it's really the same one, but we've extended it because we've given you the answer under each question.
Well, I think there's one thing we can take a look at as a group is get the current one, look at it, see what we like, don't like, and then make that recommendation to TCO, hey, let's edit this. That we can, kind of flow.
Give you some of the history. We impaneled 3 different committees to try and come up with a statewide single source PHS. Once we did, warts and bruises and all, the commissioners mandated it. They made the rule change saying everyone shall use this. What we've done most recently is if somebody wants to alter the form, as long as the questions are the same, and TJ's right, some people want to, change happy to glad or move this to here. We've kind of reviewed them and said, okay, yes, that's substantially like the one. They want it prettier, they want it nicer, they want it fillable through whatever form they're using. They want to put it online. We try not to object to that stuff because we think that's a reasonable accommodation of the commissioner's intent. So cracking that PHS open is a fun event.
You need to put like 2 people over. You got too many people. Oh, you put like 3 people over.
I'm still a little skeptical, but if the committee wants the same standardized, I'll do it. I just think that there's a lot of agencies that have gone above and beyond, and this is gonna be hard for them to accept.
So what do you want to do? Overwhelmingly, you said you support a standardized PHS, and now we're backing off of our
I
position.
think we support consideration by somebody else, not this committee right now.
So we're gonna kick the can down the road?
That's a great idea for another time. Let's stick with our hiring procedures model policy. Yeah?
Which, I mean, I think it's related, but, and I think to TJ's point, it would help both sides. But
So you're in it? You want to do it?
I like it, but I mean, it's not something I've really considered before, like you were saying. It's a new thought that I think would help. I would be more curious about the HR director and the city manager, what they thought about having it standardized and having a supplement. Because it's kind of more in that wheelhouse. I don't know.
Come on, HR.
I don't have any feelings either way. I mean, I don't have a problem with it.
I'll tell you,
The way it is now.
we used to have a supplemental polygraph report, and we ended up getting rid of it and combining that with the PHS because there's questions over here about drugs, there's questions over here about drugs.
Right.
Questions over here about theft, questions over here about theft. We just wanted it all together. So if agencies are going above and beyond about some of their questions, and they're on supplemental pages, you're gonna be kind of flipping back and forth.
Yeah, I've been through this exercise where we had a background packet that was substantial to what they put out. We were told it met the requirements, et cetera. We did change some stuff, but there's some agencies that start talking about, looking at credit scores. Is that applicable to all agencies? So it can be a whole bunch of stuff. And we know now that, and I think you referenced it, it's several hundred pages or 70 pages, whatever it is, it's got to be way less than that. So
Right.
I'm good with the standardized one. As a former chief and now a city manager, I'm good with the standardized one. I mean, it just would make sense, but I also understand that Addison is gonna not like that because they have certain things that they want to have, or Plano, or Dallas, or, any agency. So there'll be some
I
certain
think if
things.
it's gonna be used against an officer, which it sounds like it has been in the past, that you said this on this 400-page, I'm exaggerating, but 100-page, let's say that,
Oh,
document, maybe it is 200. I've done at least 2 and they're really long.
It's only 36
Plus or minus 30
Oh, no,
pages.
not at APD. It's a lot longer than
But
that.
see, that's the problem that he's talking about, is
Yeah.
people have added to.
Yeah.
Exactly, and it's just difficult. I mean, I think it has been used against them before and when the intent's not there, but how do you,
I think maybe a compromise might be that to Jessica's thing is, y'all keep rocking on the policy. You can maybe give a recommendation to the commission to revisit the PHS content and not have to take it on the wrestling match under the
Because
purview of this committee.
Other thing is, I think we have till March 1st that this policy has to be out, and so we are
Yeah.
giving ourselves a heck of a lot more work to squeeze in to the timeline.
Leave it to the commissioners.
We would take a recommendation at heart on, if this committee recommended that the commission writ large revisit the PHS and its content,
I mean, I heard this entire room volunteer to be on that next committee to do that, so
Except me.
that's
so the commission can do that by rule?
For sure.
I'm busy that day.
The commission can do that by rule currently? They could do this by rule?
oh yeah, they can instruct us to come up with a PHS, TJ and I in a dark room to come up with a PHS that we like.
And they could adopt an administrative rule requiring to use that document.
That's what I'm asking.
Well, the rule's in place now. The rule says you will use TCOL's PHS. in mechanically, we have let people, tried to give some leeway for differing agencies with differing issues. But the rules as written today say you will use the one that's downloadable from our website.
So the rules already there.
Yeah.
So we're good.
All right. So that 5-minute conversation is over.
Thank you for the 5 minutes, everyone.
Christie, I think you have the next one. Methods of notification including by in-person or certified mail related to personnel files.
Yes, so
John, if you can pull up that attachment that I sent, her recommended language.
I think the last meeting the question or inquiry came up about contemplating electronic delivery of notice. And what I proposed, was the addition in red. The agency head or the head's designees shall, not later than the 30th day after the date of inclusion, notify the affected license holder by certified mail, personal delivery, or electronically. And then providing a definition of notice electronically. Notice is considered to be received electronically by the license holder, provided it is sent to the department or personal email address listed in the licensee holder's personnel file.
Can you make that a touch larger?
Is this the correct one?
Yes, that's it.
Thank you.
I thought I had asked you to include, did I just not send the correct one? Oh, there it is, personal delivery.
Yes.
Okay, I saw it. Personal delivery or electronic. Okay. I'm trying to save our departments thousands in shipping, postage.
And I don't think there'd be, because I thought about Public Information Act potentially as being an issue, and this is just notice. It's not necessarily speaking to the negative content or whatever's in the file.
Go ahead.
Authority thing, do we have the,
Oh, so
that reading, is that adding language to the statute or statute requires certified mail in stop, no?
I think you could read it to say that the statute requires at a minimum that they notify them by certified mail. You could potentially do it other methods. One concern might be that the officer might not have access to department email address when this notification goes out.
If they're on admin leave.
Yeah, or
They're
separated.
separated.
Or separated. Got fired.
I deal with this under the rules right now all the time, and if I email, I have them respond, and then I feel like I'm relieved of the requirement to send certified mail because I can prove delivery, prove receipt. But I don't feel like I can ever assume electronic delivery, and so if that fails, then I do the registered mail and meet the requirement there.
I agree that it should be, if we're gonna use electronically in the language, it should be confirmed that it was received, whether that's through a response or some other method.
I do the same in person. I might have the constable deliver to one of his deputies the document, and then I can say that I know for a fact he got it. But if I can't, then certified mail is the one that covers me.
So maybe at the end, confirmation of receipt.
I like it.
I think if you can confirm personal electronic, then you're exempt from the certified mail requirement. You can prove delivery, right? And then certified mail is if you cannot do it the other way.
So I was a little concerned about the personal email address, but regardless, if they respond confirming they've received it, then I'm good.
And asking them for that response is probably,
Well,
because if you don't say it in the
Yeah.
email that, we need you to respond, that would be helpful for you all to note that.
I think delivery receipts stand as notice. I think that if you get a
Sure.
delivery receipt, that's good to go.
Yep.
On this one, we may have been doing it wrong, but from our civil service attorney, we will either do it in person or electronically. I don't think we've ever sent a certified letter about negative information.
This is new.
Yeah, this is new.
So,
But in other statutes where it's required, I know it's been a problem.
Yeah.
Some of our members have not been notified via certified mail when they were supposed to, so.
And I understand this is not just related to serious misconduct. This is anything negative. So if I coach an officer that they should not have ran through that stop intersection without stopping, yielding, et cetera. If I coach and I'm going to put it in their agency 360, which is electronic repository, I've got to now confirm receipt of that coaching.
If you consider that their personnel file, then yes.
That's the issue. Yeah,
We wouldn't consider that the personnel file.
correct.
We would consider that the sergeant's file.
Okay. Are you civil service? Okay. So
But would you, chief, consider that, like the one you just, example you just, counseling? Would you consider that G file or A?
G.
Okay, so I think that's, that's the difference between everybody here at this table probably has something different. And where that's kept, these are all things that are bubbling up to the surface right now. Because like I said last time, the G file is now, they're saying that you may not have to actually keep one of those. But actually, if you don't keep one of those, then where's everything going? And he just said an interesting thing, which is the sergeant's file. Well, that's really interesting. I don't know where DPS, everybody has their own thing that they're doing, but all this, I think, is gonna be handled in short order as far as, and I think, it'll come up in our future conversations about the files, but
well, I mean, right now, for me, because I don't have what chief has got, it's still an actual file. But if I put something negative in their G file, there's no notification, right, as it stands today. Now, we notify them if it goes in their A file, if there's any negative information. HR will notify them.
right. But so on the counseling, that's a G file, but you did the counseling and you did that in person, right? Or your sergeant did, right?
Would have signed, yeah.
And they would have signed. So there's your personal for that.
that's why I asked for the inclusion. Right.
Chief, real quick, this is 1705-4535. This is not A file or G file. This is the personnel file that is kept by TCO. So at the time, it's included in that file. So if you're going to report that personnel file at 30 days of separation, then that could be a single-time event, that all of the 11 verbal and written counseling, they're notified of all that's going in there. They have the right to review that file and respond.
Right.
I don't think that it contemplates that you're going to have to do it within 30 days that it occurred in inclusion in your own file.
Right. Oh, yeah. Otherwise, I'd be cussing you right now. I get that. So I'm curious, does anybody else do this? We use an electronic repository for all employee performance, minus IAs. IAs are kept separately. So every good, bad, ugly, coaching, everything is documented in Agency 360 or Guardian Tracking, which I used in Abilene. As soon as I do an entry, the employee is notified, as is their chain of command. Everybody receives an email, hey, an entry has been made on TJ. You can actually read the entry, you can actually provide rebuttal. So our intent would be whenever you separate employment within 30 days, we're going to take that, we're going to export it to a PDF document and send it over to TCO, and we're done.
Is there,
It could be, by the time, end of your career, it could be 60 pages long.
is there no retention on all those entries? Like some of the more minor stuff, it doesn't fall off in a year or 2 years or?
Keep it all.
Wow.
I'm not saying we're right, but we keep it all.
Ours does fall off.
Yeah.
If you get minor documented counseling or stuff like that, you get 6 months and I can go to IAD and go, take that, trash it.
For Dallas, is that policy or is that collective bargaining or is that something built in or is that
That's
just the
our
way it is?
policy. It's been our policy even before our contract. That's what that's what we all like.
Their charter civil service versus
Yeah,
actual
versus-
civil
yeah,
service.
yeah.
We used to do that too, and our DA told us we couldn't do that once Malcolm Morton Act came into about because they
That's
had.
what- that's what we got told too.
Because Malcolm Morton Act.
But you're talking about minor infractions.
Well, and that may be the difference.
Yeah.
And he had to draw a line. He said, I don't want to sit there and look at every one of the things,
You gotta remember,
Yeah.
several of our levels of punishment, I guess, there, you don't even get to dispute. If it's a division rec, a division one-star chief can give you written you have to take it. There is no, I'm gonna dispute it, fight it, but that's our world.
Yeah.
So.
But like you were saying, Chief, everything in that file, that PDF that you were gonna export, they've been notified along the line each time somehow that was in their file.
There's no evaluation by ambush anymore if you have an electronic repository. I know exactly what's in my G file, I know what's in my A file, because I get simultaneous notice. But to your point, yeah, I'll be Victor for a second. What's minor? Who gets to define minor?
Well,
You.
but by our classification of, whether it be supervisor's report, document counseling, written that's going to determine your severity of what you've done.
Okay, so what feedback do you have for Christie other than the confirmation receipt, acknowledgement of receipt? Some way to acknowledge. TJ, does that satisfy the concern from an enforcement perspective?
So if you send it out electronically and you don't get a response because the officer doesn't want to, or for whatever reason, you're going to have to send him.
Sure.
There's got to be a time where you're going to have to, if you don't receive electronic confirmation within 5 business days, you're going to have to mail them.
But that limits should take a lot of that off.
Or whatever, 10, whatever you want.
Aaron, does this satisfy you from a legal reading?
Sure, when we get the language finalized, we can see it, but it's sounding good.
Good answer.
Okay. All right. I think we have that. Christie, if you'll get me your rewrite. TJ, get me your rewrite. Jessica, I'll share all these notes as it relates to the timely manner, so you can make some rewrites with the 3J committee. And we'll meet again in December.
And the misconduct stuff can be tweaked a little bit too.
And the misconduct is going to be, well, we already have the language, whatever we codified, we're going to stick with that language that the group reviewed. The whole purpose of this next meeting is to get to commitment.
Okay.
So I just need to read drafts back, and then I'll share it with the group so y'all can read ahead of time. And then in December, we'll get to commitment. And then I would imagine the final thing will be to actually execute the policy drafts to it. Agreed?
Do you mind if I tweak the misconduct stuff a little bit or mess with it anyway? Okay.
And it'd be in my notes, exactly what we came up with. Question for the group. Who in here really enjoys doing policy drafts and wants to take the final proposed language from the committee and actually execute the 2 drafts? I will say that TJ did a really good job on his draft. It was actually read like a policy, not to actually implant any idea.
All in favor of TJ doing it? You're done. You got it. All right. Motion carries. Ours. TJ is going to actually write the final policy draft. Yeah, no kidding. So, come back in December. Work toward the commitments of the language. Break. TJ goes back, codifies the actual 2 sample policies. Meet in January. Finalize any suggestions in January, so we can have the team poll by February. And then we have to get before the commission before March 1. Agreed?
Are we also writing a model policy on personnel file?
Yeah. So we're going to contemplate that. Okay. All right, Madam Co-Chair, what do you want to do on personnel policy?
Sounds like a good job for today.
What's the law change there? What are they asking us to do on that we need to codify?
I think it's pretty prescriptive on what would be in.
Requires the head of a law enforcement agency or the head's designee to maintain a personnel file on each license holder employed by the agency that contains any letter, memorandum, or document
commendation, congratulation, honor, misconduct, periodic evaluation, and provide that the letter, memorandum, or document relating to the alleged misconduct may not be placed in the license holder's personnel file if the enforcement agency determines that there is insufficient evidence to sustain the charge of misconduct.
So that's that 143, I believe.
If a negative letter, memorandum, document, or other notation of negative impact is included in the license holder's personnel file, just like that in here.
That's where we got to this part.
Okay.
So we did contemplate the personal file a little bit, but only to the extent that we talked about the children of grade.
Right. Okay. So why don't we just do a quick set, this one on, agree to serve on that, who else wants to serve on this?
I'll be on.
Okay, who else? Okay, one more. You? Alright, so hang on, let me get this real quick. Alright. Jennifer Karen, co-daughter. Okay. Good, good, good. What do we want, we still have an hour, do we want to contemplate it now?
No.
It was rhetorical apparently. All right, anything else from T-Pool staff that we need to consider?
The agenda could still have to be published before Thanksgiving.
The agenda? Okay. I think we can agree that the agenda will be to finalize draft language related to the may investigate, the timely manner, best practice policy associated with hiring a license holder, and then methods of notification, and then review initial draft of personnel files. That would be the agenda in probably that order. Agreed? So I would enumerate 5 bullet points there. Okay? All right, thank you all.
What are we meeting again?
Public comment? Public comment, okay, is there, can staff tell me if there's any public comment? I thought it wasn't live, so how could they do public comment?
Like it should be physically here somewhere. Just for public
This is a trick, Aaron, this is a trick. This is like spelling support, understand? All right, I hear no, is there any public comment? Hearing no public comment, we'll close the public comment session, thank you. Anything else?
What December